All rise for the pledge, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome to the November Board of Trustees meeting here. We always start off with the recognizing the Employee of the Month. So for the month of November, Joe Smith from the Parks Department was recognized. He's a groundskeepers 3. And from his supervisor, Larry Winchick, Joe has worked very hard transforming Flying Point Park and Agawam and 25 Jobs Lane and the dog park and the monument. His programs all really made a difference for all to see. The entire department has noticed a change in the way they look and appreciate it even more. They all commended him for his efforts and do so, and again, with helping to create a more positive outlook for everyone. It certainly does. So Joe does a great job. He spent years at Shinnecock, and now he works for us for the last several years. And so congratulations, Joe, and thanks for being part of the village team here. We have a public comment section here. Get an opportunity to sign up, but we also have some public hearings here. So if you're not speaking about a public hearing and you want to make a public comment, you could raise your hand. So nobody signed up. So is anybody here? Okay, I guess everybody's here for the public hearing. So okay, we have no board presentations tonight. We've got public hearings on the community development program. We have some presentations on that. So I want to make a motion to open the public hearing on the community development program.
Second. Second. All in favor?
Aye. What the just to give everybody the community development program is a $17,800 federal community development block grant funds, and these funds may be used and have been previously used for a variety of projects to be selected by this board. We had applicants who submitted applications, and so we've got a couple of people who are going to come and present today. So Steve, you want to?
So we have Human Resources.
Terry Landowski, Human Resources of the Hamptons. How's everyone? Last year, my predecessor did this presentation and alluded in the presentation to the fact that we may be dissolving the Medical Transportation Department, and that is what has transpired this year. There were a number of factors that led to that decision, including the retirement of Bill Tupper, who was the driver for the program, as well as the fact that the cost of operation for that program increased by nearly 800% since its inception. As a result, this year we're asking for funds to be allotted to the salary of our food pantry manager to come in an extra day each week so we can open the food pantry specifically to serve senior citizens 1 day a week. At that time, we'll have access to the handicap ramp, and we will have a army of young volunteers to be able to assist in carrying the groceries to the seniors' cars at the time.
Great. You guys have any questions?
Do they tell us how much they're asking?
Well, actually, it's up to us. Normally what we do is we split it evenly, which we've done in the past. So, and you got a polar bear plunge coming up?
The plunge is a month from today.
So everybody's going to show up.
Yes, please come down. Jump into the ocean, December 13th, 10 a.m., Coopers.
I know.
So we're going to keep track of who speaks tonight.
We'll keep you automatically registered.
Yeah, so.
Forecast is warm and sunny.
Warm and sunny, yes, 73 at Cooper's Beach on December 3rd.
Sounds like heaven to me.
It's great. Okay. Well, thank you.
Thank you.
Rachel.
Hello, everyone.
My name is Rachel Copt, and I have been the director of the Southampton Daycare for this is my 4th year. And I first wanted to thank everyone for the continued support over many, many years that you've been part of our program since before I even got here. Our daycare was founded by the community member Kathleen Davis. The center in 1985, and the center moved to its permanent location on David White's Lane 12 years ago. We are still providing a safe, nurturing environment for children of working families. Many of our local families struggle financially, and daycare can cost up to $12,000 per child a year. And there are many single-parent families that attend and work more than one job just to get by. Being a nonprofit organization, we rely greatly on the support of our community. This year we have successfully had some fundraisers, including scholastic book sales. We've had jewelry sales. We just had one at Alex and Ani. We've done car washes, and we're actually going to be doing next Tuesday night at Red Bar. We still have tickets available. If anyone is interested, to call the Southampton Daycare. It'll be a nice evening. We're doing a dinner and a silent auction. And we've been fortunate for, like I said, many years to for you to help us provide the parents with scholarships and also purchasing supplies and educational tools. And I ask you to continue supporting our local daycare.
All right, great.
Okay.
It's next Tuesday at Red Bar. It's
Yes.
what's the cost?
It's $85. Cocktail hour is 5:30 to 6:30, and a seated dinner includes drinks and 3-course meal. 6:30 to 8:30. Silent auction. We still have tickets.
And we got a pretty good crowd out here.
Yes. So please, Southampton Daycare Center.
It's on a Tuesday night, so.
Yeah. So please call. We have some tickets left. So it's for a great cause.
How many kids do you guys have?
We have 35 children.
35 children.
Yeah, ages 2 to 5. Yeah.
It's a great place.
Yes.
It's a
Thank you
great
so
place.
much.
Thanks.
All right. Thank you.
Okay, thanks, Rachel.
Okay, thank you.
Anyone else want to speak in reference to the, yes?
Good evening, everyone. I'm Brenda Simmons. I am the director of the African American Museum. And we started the museum project back in 2005. It's been a long journey. But originally, the building was an old barbershop and beautician, and actually my aunt was the beautician in there. And when I was like 9 or 10, I used to go in there and answer the phones for her and write the appointments down. So it's very dear to me personally. And the project has been ongoing for a while, but we have been a virtue museum. And we have done a lot of projects. We've been involved with, I was going to pass these out too, matter of fact, just to give you guys some things that we've done. Been very busy over the years. And the location is at 245 North Sea Road, I should say that. And we've been involved in a lot of different projects. We was involved in to save a farmhouse, an African-American farmhouse in Sagaponack. We've been instrumental in the Pierce Concert House. And we have also put on a lot of film festivals. Matter of fact, our 9th annual film festival was this year, which was very, very successful. We had things like, most of the time we have our opening night. We geared toward the students and the school system. And so we usually have an opening night where we have a Q&A with the students, and we reach out to all the local schools. And we've been very successful with that and doing projects where talking about kids making good choices and just really dealing with a lot of things that students would be interested in to help them in their future as well. And also, we are moving forward to getting the shovel in the ground, so we're very, very close to doing that. We're very, very excited about that. But the money we're going to be using this time will be using money to have handicap accessibility for the building.
Okay.
So that's what we're going to be using the project for.
Okay. Excellent, great.
Thank you.
All right. Thanks, Brenda. We had some great films this year at the film festival, and a lot of people showed up, so great job. Anyone else would like to speak about the community block grant? Okay. So why don't we close the public hearing on this? I'll make a motion to close the public hearing.
Second?
Second.
All in favor?
Aye. Okay, so we have, next public hearing is the local law number 4, request for exemption at 320 Murray Place, LLC. I'll make a motion to open the public hearing for the request for exemption at 320 Murray Place LLC.
Second?
Second.
All in favor? Aye. Should I proceed?
Rick, you want to start this out, or no?
I don't see any reason for me
Okay.
to say
Why don't
anything.
we
It's
just,
an application.
Application, okay.
Let me, if I may, my name is John Bennett, and I represent the applicant. And with me this evening, well, first of all, let me take care of the proof of notification, which I'm handing to Mr. Funch. And then, what I'll hand to you each, I have an original and 1, 2, 3, 4, 5, 6, 7 copies. Well, why not, Steve, I'll give you the original and 5 for the trustees. And, council, I did give a copy of this to Mr. Sullivan's, who I presume is Mr. Sullivan's counsel. So, we're here for an application for relief from the moratorium. So with me is Melissa Dedovich, Tim Haynes from Haynes Roberts, and the principals of the limited liability company, Mitchell and Kathy Jacobson. It's an application for relief from the flood zone height moratorium. Some history, I think, is very important in this application because you'll quickly see that my client has been a very conscientious and responsible purchaser of this property. And has, you'll see, expended an enormous amount of energy and effort in designing a house which is consistent with what I will say, the current state of the law in the village of Southampton, which state of the law has been suspended for some time pursuant to local law number 4. My client purchased this property in May of 2013. He came to me. He had been looking at the property. He was looking at it with an architect, with Tim Haynes, and wanted to make sure that the property was suitable for his vision for the property and Mr. Haynes' vision for the property. So we undertook a fairly exhaustive bit of due diligence on this property. As you can imagine, for a piece of property for which the ultimate purchase price was $26 million. It was a piece of property that was improved by a house that at the time was owned by the Kolokundis family, and we were very sure to make sure that there were appropriate permits to raise that house. It had been a house at one time that had some historical interest, but it had been so changed over the years by additions done by the Kolokundis family that the Architectural Review Board agreed that there was no benefit to preserving it. This house, which, by the way, is not visible from any public right-of-way. It's buried deep into on the ocean front in what we all locally know as the Murray McDonald compound, thus the Murray Place. Probably the most important for the subject matter of this evening, which is the height of the house, my client did, prior to purchasing the house, make sure that the height limitations that existed in the village were not going to come into conflict with his proposed plan for the house. So what we did do is counsel for the seller of the property, and I met with Mr. Foster, and Mr. Foster was kind enough to do what he has done on many, many applications. We prepared a letter that memorialized Gil Flanagan's and my conversations with Mr. Foster, and Mr. Foster countersigned that letter. That's Exhibit A to the property. And he stated, which shouldn't come as a surprise to anybody, that it had been the practice and the interpretation of the village building inspector for some years, even before Mr. Foster was the village building inspector, to use the starting off point for the construction of homes in flood zones as the base floodplain elevation, and now base floodplain elevation +2, plus 27 feet for a flat roofed house, 35 feet for a gabled house with certain pitches, and that again is at Exhibit A to my letter to you of even date. I think it's very important for the board to know, if you haven't already been apprised of this, that Mr. Foster's interpretation was noted approvingly in a recent case against the Board of Architectural Review and the building inspector, specifically Dean and Hackett versus Board of Architectural Review, which is Exhibit B to to my letter to you. And I think this is important because there should be no question whatsoever but that Mr. Foster had been appropriately interpreting the codes of the Village of Southampton and the Federal Emergency Management Agency codes as adopted by the Village of Southampton to properly take the starting off point from the base floodplain elevation +2. And it's helpful to hear the words of Mr. Foster as quoted by Judge Santarelli in his decision, which denied it's not a final disposition, but it denied a request for a preliminary relief in the Dean and Hackett versus ARB matter. And the judge noted approvingly Mr. Foster's language. It has been the practice of the Village Building Department since even prior to my appointment as the building inspector that the starting off point for height of houses in the FEMA-created flood zones is taken from the FEMA base floodplain elevation requirement, and more recently with the addition of the 2 feet freeboard requirement from the base floodplain elevation +2 feet. I have reviewed well over 60 applications for constructions of houses in flood zones in the Village of Southampton and have consistently utilized such practice in connection with the issuance of buildings permits. Such practice was used in the connection of the house, the EAM 40 Meadow Lane house, as well as the adjoining houses, which is a similar thing that happened in this case. We'll demonstrate to you that the Sullivan house also used this calculation for height. So in terms of any sort of self-created hardship, in terms of reasonable reliance, reasonable investment-backed expectations, certainly the Jacobson did their homework and were assured in a very complete and intelligent review of the property that the base floodplain elevation +2 was the jumping off point. So not only do you have Mr. Foster's finding, but you have that cited approvingly by Judge Santarelli. Clients again purchased the property for $26 million, obviously in reliance on this letter and a 30-year-old code interpretation, all in good faith, so they could build a 2-story, 27-foot-tall house in compliance with the general area and also compliance with the building code. And I think it's important because one of the things you're talking about is height here is that it's a 27-foot high house. It's taken from the base floodplain elevation +2. It's a 27-foot high house, which again, there's been a lot of conversation about this, about what happens when you start restricting the height of houses more restrictive than probably 60 homes that have been built in the village. Leaving fairness aside, what that does to architectural flexibility. But in any event, we have before you we have a 27-foot high home, and I think it might be good. I'm not going to stop my presentation, but perhaps it's best if Melissa and Tim Haynes could just show us so the board could see what we're dealing with here. I'll keep talking because you have a long evening in front of you, but we're going to talk about these these boards, but I wanted to get them in front of you so you could start visualizing them. But obviously, a significant part of the value of this house is the ability to build a 2-story house, and certainly something that would have to be built in conformance with the safe harbor in the moratorium. And local law number 4 would not be something that would be at all commensurate with the value that was paid for the property. We then, armed with the tear down approval, armed with with Mr. Foster's letter, we then went to the Architectural Review Board, and the Architectural Review Board is important because, indeed, one of the things that you say in your local law number 4 is that you can look to the Architectural Review Board for guidance in how best to handle these applications before you. I'm going to read you some quotes from the ARB. I'm going to read you a letter from the ARB, but it's important also for you to realize in terms of hardship, in terms of fairness, at this point, just at this point, in addition to the acquisition cost, Mr. and Mrs. Jacobson had expended in design, architectural fees, landscape fees, legal, planning, and engineering for this house, all in compliance with the current codes, as they were smart and prudent enough to assure themselves of, approximately $455,000. That doesn't include acquisition costs. That's design, landscape, because we wanted to make sure that not only did we have a house that was low-lying, but also a landscape design that was protective of what we had been told were the concerns of the neighbor to the west. So again, we went before the Architectural Review Board, and in addition to going before the Architectural Review Board, the Architectural Review Board wanted us to create a mock-up of the height and the screening out at the site, and we did that. And I tell you that because some of the comments from the Architectural Review Board make sense when you realize that we did, at great expense, create a mock-up of the height to see what the effect would be on the adjoining neighbors. The adjoining neighbor to the west, who seem to be the most concerned, despite the fact that, as we'll demonstrate to you, that house is higher by about, Melissa, how many feet?
3.5 feet.
3.5 feet. And the board had some comments at that time, and amongst their comments were the following. Mr. Hogue, and again, he had been out there at the site to see the mock-up, when challenged about the appropriateness of the siding and the height of the house and its effect on the existing house to the west, said the following. I saw the mock-up, you guys, he's talking about us, did exactly what we asked. For me at least, I won't speak for the other board members, it was extremely helpful. I'm happy that the tool was employed here. Very clearly, it made my decision absolutely crystal. I'm satisfied that the mock-up provided to me proved to me the privacy of the house, i.e. the privacy of the house to the west as it relates to the subject house, and the privacy of the subject house as it relates to the house to the west, the structure, and how it relates not just to that neighbor, but quite frankly to some of the other neighbors as well. I think the landscape plan has been done is exceptional. As Pastor said, we very much appreciate the time and trouble you took to give us the answers to our questions, and really a picture is worth 1,000 words. I have absolutely no issue with this, and you have answered all my questions to my satisfaction. And Mr. Brady, I agree with all that has been said. I have no issues at all. I think it's a beautiful project. In addition to the comments at the meeting, we do have at exhibit number C for you a letter from counsel, signed by counsel from the Board of Architectural Review Board after his inquiry to the board members, and the original signed copy has been delivered to the trustee's office. What you're seeing is an unsigned copy, but I will attest to you that it is the same as the signed copy. And it's addressed to Mayor Epley and the members of the Board of Trustees. The Board of Architectural Review and Historic Preservation wishes to advise the Board of Trustees that the application of the above referenced owner was the subject of several hearings before the Board. The Board considered in detail the style and architecture of the proposed residence and received extensive commentary from neighboring property owners. The Board favored approval of the project and would have voted to approve the application at the regular meeting, but it deferred the vote in deference to the moratorium on certain construction to which it was subject, approved by the trustees, anticipated to take effect the next day. So even though the moratorium hadn't had effect because it hadn't been filed, the Board deferred to the trustees' wishes. Now, not only do we have the Board of Architectural Review in support of the project, but we also have numerous neighbors who are in support of the project. If you look at Exhibit D to my letter, you will see a tax map which shows in pink, I'll read off the names, and I'll read one of the letters as an illustrative example of the letters, because they're pretty much the same. It shows in pink the letters of support from the neighbors. It shows in yellow the subject property. There was a letter of support from the neighbor to the due east. That's the Edelman. That's if you're familiar with the area, that's a Jaffe that's off of Barron's Lane. And the neighbors of the neighbors skipping the Sullivans, who are concerned about the house, the neighbors to the three neighbors on the beach to the west, as well as quite a few residents in the area, and I think also most important, Mr. Karp, who is due north of the house. Let me give you the list of names, and I'll read first. Well, let me read first one of the letters of support, and they're all the same, but they say that they have reviewed the request for the exemption for the moratorium at 320 Murray Place, Southampton, and have no objection to the village trustees granting the request. And those letters were signed by the following individuals. Curtis Schenker at 9 Squabble Lane, Leonard Stern at 3 Squabble Lane, Howard Stern at 17 Squabble Lane, Trish McVoy at 6 Squabble Lane, Holly Anderson at 1 Squabble Lane, Joseph Edelman, 380 Barron's Lane. He's the neighbor directly to the east. Thomas Bianco at 181 Murray Place, Peter Brodsky at 251 Murray Place, Sidney Goodfriend at 234 Murray Place, George Kaufman at 266 Murray Place, Stephen Karp at 310 Murray Place, and again, he's the neighbor to the north, directly to the north, and Susan Mendick at 139 Murray Lane. Now, I give you these letters to show that there is significant support in the community for this application, but also because one of the things that you say in your standards is, will it do any damage, the application, will the application do any damage to, among other things, the neighborhood? And here's proof positive that that is simply not the case. Indeed, there will be no impact whatsoever onto the character of the neighborhood. I give you for your consideration 2 cases which I was involved in the litigation of, Coleman versus Corman and matter of Dolphin versus Zoning Board of Appeals, both of which, I'll quote you from one of them, the fact that the neighbors approved the proposal or didn't have any opposition to the proposal demonstrated that the proposal, quote, did not impose a substantial change in the character of the neighborhood. So it's important that this be brought to your attention because it is, again, indicia of the fact that there will be no change to the character of the neighborhood. Let's talk a little bit, I guess, about what the proposal consists of. One of the things that we
John? John?
Yes.
Just take the mic with you if you're going to be over there.
Oh, okay. There are a couple of things that we wanted to bring to your attention. Through conversations with various village officials, we've been able to determine that one of the things that you folks are thinking about is the imposition of a 45-degree, sky plane. Coming up 5 feet from the existing average grade around the front of the house, and then a 45-degree angle. We call it a pyramid law. Some people call it a sky plane, but there it is as shown on this house. And this would be the, I guess this is the south elevation of the house, is it, Tim? Oh, it's the north elevation. I'm sorry. This is the north elevation. I'm sorry. This is the front of the house. So driving down Murray Place, this is what you see when you come into the driveway. The Sullivan house is here, and the Edelman house is here. So we handily meet the 45-degree sky plane, which again is not anywhere in the code, but based upon what we've been able to determine is something that the board is looking at. We also were 44 feet at the top of these wings from sea level, and so what we get there by taking the base floodplain elevation +2 and adding 27 feet for this flat-roofed house. So let's talk about what some of the concerns were that were voiced at the hearings for the moratorium, and one of the one that I kept on hearing anyway was that we're concerned that these homes are going to tower over their neighbors, and that is unequivocally, demonstrably not going to happen in this particular instance. What we have for you here is the elevations above sea level for the homes in the area, and I want to. Jacobson house. And I want to point out a couple of things. One is we're at 44, as we stated. The Sullivan house is at 47.5. And the easterly side of the Sullivan house is 80 feet from the westerly side of the Jacobson house. You can see we've drawn that on one of the handouts. So not only are we lower than the Sullivan house, but we're also pretty far away from the Sullivan house, 83 feet. Then the Edelman house to the east. The Edelman house is a somewhat low-slung Jaffe, as those homes tend to be. We're at 38 feet with that, but it's important to note, one, that there's a letter of support, or no opposition, I should say, from Mr. Edelman. Also, in between the Edelman house and the Jacobson house, there are some significant accessory improvements. There's a tennis court, there's a swimming pool, and the easterly wall of the Jacobson house is approximately 280 feet away from the westerly wall of the Edelman house, which is approximately a football field away. So I really challenge anyone to suggest in any manner, form, function, whatever, that this 27-foot from base floodplain elevation house, which is shorter than the neighboring house to the west and 280 feet away from the neighboring house to the east, could ever be characterized as towering over the either one of the houses. That's a great view right there. You see where the Jacobson house in relation to the Sullivan house. There was also, as Mr. Hoag noted in his comments before the Architectural Review Board, there's a significant landscape plan, the attempt of which is to create privacy. I mean, Mr. and Mrs. Jacobson don't value their privacy as much as Mr. Sullivan does. So you can see an extensive landscaping plan which is raised just to do that. Tim, if I may, you're so good at presenting these plans. I was wondering if you could just take the board through what the thoughts were and what the vision for the property was and what the house was.
Sure.
Thanks.
Hi, how are you? The concept of the house was that of capturing the horizon line of the ocean. So for that reason, the main volume of the house that goes from east to west was a very low, one-story, repetitive facade of steel and glass, which in our architectural vision was to create a three-dimensional built sort of manifestation of the sea sitting out beyond, so that the horizon line of the ocean became symbolized by the architecture of a long, low, simple, minimal house. And so that was our impetus for the design. And then the sort of wings of the house that go in the north-south direction were covered in cedar shingles and became the more private aspects of the house, where the bedrooms and the kitchens and those parts of the house were. And they sort of reached out as arms into the landscape to anchor this sort of encapsulated architectural realization of an abstraction of the horizon line. And then I asked Ed Hollander to further take that and just create this whole sort of sculpture sitting and recreating the dunes that do exist, to remove 98% of the grass from the site and just have the actual natural dunes, recreate them going entirely through the project, so that there was the sense of a man-made landscape would disappear, and a naturalistic landscape where this sort of glass bar of a horizon line of the main house would sit and would get then re-anchored back into those dunes by the natural shingle arms that tied it back into that landscape. So that was our concept architecturally.
And I must add that great pains were taken to create privacy not only for, you can see the Hollander landscape plan, not only for the Jacobson house, but as that would relate to the Sullivan house.
And I'm sure as you saw architecturally from the beach side, I mean, it really is the opposite of trying to tower. It's trying to literally stay very low and consistent, and to not be redundant, sort of be that manifestation of the calm ocean in that horizontal plane, and to be the opposite of verticality.
Some of the other things that were important before the Architectural Review Board in terms of attempting to make sure that we didn't have any sort of impact on the neighbor is the second floor of the neighboring home is about within 6 inches of the floor level of the second floor of the proposed 320 Murray Place residence. So the board was very happy about that. There was also significant effort to make sure that the materials we'd used would minimize any sort of glare. So I think you have in front of you probably a poster child for an exemption here. There is no it's hard to find a more deserving application for exemption here. There's no self-created harm. The homeowners did their homework. They've designed a low-lying house within the existing sections of the law, as not only was explained to them, but was memorialized in a letter from the building inspector, and as we see, a court has stated is the appropriate way to look at these things. Significant impact. Very significant impact. Goes without saying, this house was purchased for the purpose of constructing a 2-story, 27-foot single-family residence. I know that there have been some concerns. There were some concerns mentioned at the hearings about the location of the. This is west. Where's
This is east.
That's okay. Sullivan is here, correct? There was some request to shift this house, a portion of the house back to, the request was, could this southerly portion of the Jacobson house be in line with the southerly portion of the Sullivan house? But I will tell you, there's nothing in your moratorium which deals with these things. They're conforming setbacks. As a matter of fact, far from being aggressive, the Jacobson house is 22 and a half feet landward of where it could be. In other words, it's 122.5 feet behind the dune crest. So it's not someone who's trying to get as close to the dune crest as they can, far from it. And you know, if you look at an aerial photograph of the of Meadow Lane and Gin Lane, you will see that some of this dune setback stuff is sort of luck of the draw, because the dune setback is not a straight shot from you know, the heliport all the way down to Fowler Street. It undulates. It's the 100-foot dune crest setback is a function of the topography that exists on the property. But that is all. Those are all site plan issues. Every bit of this setback meets the required zoning setbacks on the main house. So. We think we've been extremely sensitive to everybody. We don't really know what else, as did the ARB, not only in their comments that we've given from the meetings, but also in their letter. And I know Mr. Jacobson wanted to talk to you, and I think it's important that you hear him say a few words. There's nothing like having the actual person who's, you know, whose home it is and who's truly the involved person, truly the stakeholder, before you. But before I bring him up to say a few words, I really don't know what else you could ask this applicant to do. They've been very sensitive to everybody.
Council, I have one question, and since you're the architect and you're present, obviously there's a financial hardship on the delay, and obviously Mr. Jacobson has spent numerous time and money. But can you tell me, is there a hardship on lowering the roof line of that two-story? I mean, I see your concept of trying to get a view of the ocean. Maybe you could tell us why it's not feasible to lower that roof line.
Well, we've got FEMA, and then we have the equipment, which also can't be below a certain line. And so that is setting where we're starting the house. And then in our two-story sections, we don't have excessively tall ceilings on the 2 stories. The main block of the house has where the higher ceilings are. The house is quite
17 feet or something.
This is where we do have the tall ceilings, but it is significantly lower than what's required. Where we need to get 2 stories, we've sort of sandwiched those 2 stories into lower ceilinged rooms, so bedrooms and kitchens and things like that are in the support wings. And below that, we have to run all of the plumbing and the air conditioning and all of the support for it. So compressing it starts to make these houses unbuildable.
I mean, the house as it is 20, the vertical distance from the bottom to the top is 27 feet, which is not a tall house at all. The average
I
gable
realize
roof
that.
2.5 story house is 35 feet.
When you have
And the question becomes, if you take all those questions and put them into what you're looking for, the question becomes where you're trying to balance any alleged harm to the neighbor with the harm to the applicant, who essentially what you're asking him is to construct a 1-story house, which I think that. It goes without saying that somebody doesn't pay $26 million for a piece of property to construct a 1-story house.
Okay.
And that would, I would say, that would be, in effect, a taking of a large portion of the value of this house, of this property.
But is there also a loss in form and function by reducing the height?
You actually need the room in between. I'm sorry. I feel like I'm on stage.
You're at the end of the...
I'm at the end, I'm so bad. There's also an issue, as Tim touched on, getting the electricals and the ductwork in between the floor plates. You have to have a certain distance, since we don't have an attic to play with, we don't have a basement to play with, to run all that, the septic system, all that through the floor plates. You can only shrink it so much. I mean, what are the ceiling heights on our...
A little over 9 feet on the second, and I think we're a little taller than that, maybe around 10 on the ground of those zones.
And these aren't unusual for houses nowadays.
Actually, they're
very modest. Very modest.
They're hardly pushing the envelope.
Okay.
Mitch? No? Yes? Oh. Okay. If it's okay, Mr. Jacobson is going to hold off until anyone, and see if anyone else has anything to say.
He's going to wait until...
Yep.
Actually, put the... does anyone from the board have any questions for Mr. Bennett while he's here? More questions?
No, that's okay.
John, I realize, listening to what you're saying, that no part of the house, it could actually be much closer to the dune line than it is, so that...
Over 20 feet.
Yes.
And that's one of the reasons why you buy a house on the ocean.
And of course, you mentioned the fact that some thought if that westerly wing was pushed back, at least it would give the immediate neighbor to the west, a broader view too. Did you ever give any thought, if you didn't want to do that, and I understand you may have the right to do it, so I'm not, but could you, I noticed that the house doesn't appear to have any decking, where you had a party and people want to have cocktails and want to be on the outside. Would it have been possible to make a deck on that westerly wing so that only some portion of it would be lower than the rest of the house, and it wouldn't protrude, and their site, and it just, it would be a nice thing to do, and I'm not saying something you have to do. Do you understand what I'm saying?
This is a moratorium. John. Reportedly about height. And we're more than conforming to that setback, and I don't think it's fair at all to ask someone to do that. We're not here for a site plan review, and the Architectural Review Board quite pointedly kept on pointing that out to the Sullivans. And so I'm not inclined to even offer that.
Within their rights, and I understand that.
I don't think it's fair to take it into consideration in your analysis or your calculus about the appropriateness of granting this relief. Many people have homes on the oceans that are somewhat obscured by, rare is the person, except when they have a pre-existing non-conforming house that's out there on the dune. Rare is the person that has on the ocean that has an unobstructed peripheral view. So again, that's a site plan element, which I think the only single-family residence elements that are subject to site plan in the village, Rick will correct me if I'm wrong, are a tennis court, and on a flag lot, the landscaping. I don't think it's. I think you get into a dangerous situation when you start asking people to push back from what their allowable front yard, side yard, rear yards are. So we would be disinclined to make any modifications.
Any other question from the board?
No, I'm kind of curious what FEMA requirements were for some of the houses, like 317 Murray Place, at the time that was built? Because I know that it's changed.
It's changed.
And that is 47.6 feet in height, and this is 44. And one squabble is 45.6. So, and then the one that's closest to is 43.817, and that's FEMA Zone X. But I'm just kind of curious, because if it was like 9 plus 2, those houses were significantly higher than what was required for FEMA. I mean, they went up much, much higher. And the other thing is, we went over there to take a look at it, and my biggest concern on all of this was 317, because I wanted to see if the house was blocking its view in any way to the east and to the west, and it isn't. And the other thing is that the other thing I looked at was, because this was important to me, the windows that faced east on that house, if that property, if that was blocking the view where they had to look at this house, and they're very small windows on that side. I mean, really small windows. Kind of shocked me that, you had such a beautiful view, and that's the size of the window that you picked. So those two things were satisfied as far as I'm concerned, because I had great concern over that. But I mean, I look at 47.6 feet. I don't know what year that was built.
Well, remember, that's a pitched roof house as well, so you pick up
8 feet.
8 feet.
Right.
You do that. It probably was built to a less stringent, it might have been an AE zone at that point.
Might have been 12 then.
Might have been 12. And the other thing, I can't leave this evening without saying this. I think the village's concerns about height are being really pushed on a small bunch of property owners, much to their detriment and in a very unfair way, because every one of these people did their homework, and I really don't know why the village hasn't taken what I think could be a much better route and a much more significant inquiry, which is why are these FEMA zones, why have they been changed so significantly? And I know when John Foster wanted to talk to you as an illustrative example is 40 Meadow Lane, I know why you didn't let him do it, but let's just for an example, that that property was in an AE9. Well, you weren't involved in that. That house was in an AE8, an AE8. And FEMA came in and put it into a VE16. And not only that, they bled the VE16 zone across, that's Meadow there, Meadow Lane. So I'm wondering why, as a community, we're not asking FEMA, in the last 20 years, do you really think that during a flood event, what's changed that in the last 20 years, the flood waters are going to be 10 feet higher?
Sandy.
10 feet higher. 10 feet higher.
Sandy.
No, it's pre-Sandy that those changes were made. So I'm wondering whether or not an inquiry could be made, because that would relieve some of these concerns. These houses are at this level because there's no other place for them to go, because you have community flood rating you have to be concerned about. You have to put them there. And I think that should be an inquiry. Some of these zones are, in most experts' eyes, they're overkill. You go from an AE8 to a VE16 plus the freeboard. All of a sudden you're in a VE18, and the A is different from the V. And the A is the base floodplain establishes the first floor level. In a V, the base floodplain establishes the lowest structural horizontal member. So if you're in an AE10, if the first floor you're standing on is at 10 feet plus 2, you're 12 feet above sea level. If you're, say, in a VE10, you have to add another 2 or 3 feet of that because the lowest horizontal structural member has to be up there. So, I mean, that's a broader discussion, but I think it's worth an inquiry to the feds as to why they've so drastically elevated some of these zones. It's having an effect, I understand, but it really, the homeowner, the property owner, is an innocent bystander getting run over by this stuff.
But you can also, just real quick, just to comment on the chart you were mentioning, even with us being FEMA compliant to AE15, we're still not the highest, we're not the lowest. We're right in the middle.
I think that's why they have to look at each one. To me, you have to look at each one now in this time individually, because if you just blanket approve them, I think a lot of this has to do, because we've all, obviously, architects have been talking about this. I think a lot of it has to do, and some of the problems have occurred with the size of the piece of land, I think can change the impact of a house going onto it, and how low the natural topography is vis-a-vis how much you're going to have to build up. If you're building up, if something's almost, at 2 and you've got to build up to 14, it's a massive impact. If you're talking about building up 5 feet and you have many acres, probably you're going to find things are within a couple of feet of what's existing, but you have to protect the village from the low, small piece of land where it goes up, and then the house goes up, and then it wreaks havoc, I think. It has the potential to wreak havoc, and that's going to be the difficult task. But now, looking at them as each individual cases, you just have to, I would assume you'd be looking to make sure that the worst case scenario isn't happening, where it's 12 feet of fill plus a house going up on top of that on a acre and all of a sudden you have a tower beside you.
But again, I ask you to superimpose over all your analysis.
Described 40 Meadow Lane.
I ask you to superimpose.
Thank you.
I ask you to superimpose. I ask you to superimpose over your analysis the purpose for the moratorium, which was the concern that houses were going to tower over their neighbors. 280 feet from the neighbor to the east, 80 feet from the neighbor to the west. Neighbor to the west is higher.
Yeah, thanks. Okay, anyone else would like to speak in reference to this? He wants to speak after.
Good afternoon, good evening, members of the board. It seems, I don't know, late. But anyway, I appreciate the opportunity to address the board I'm the attorney that represents Mr. and Mrs. Sullivan, the owners of 317 Murray Place. That property has been discussed as part of the application.
Just state your name, please.
My name's Diane Leverrier. I'm an attorney with Jordan and Leverrier PC, located at 257 Pantago Road, East Hampton, New York, 11937. And I just heard a lot with regard to the application, and the thing that sort of rings the most with me in terms of the presentation that was just made by Mr. Bennett was a lot of the questions that are raised by this application, and questions that actually he just raised in terms of the potential impacts of the proposed development on the community, and even on the regulations as a whole. He talked about the fact that maybe we should inquire of the feds as to why they drastically increased the zones. Maybe we should inquire of FEMA whether these changes should even be made. Also, questions were raised with regard to the application itself. Why can't these things be moved back? Why can't you move the house back and comply, bring it back down to the natural grade? Because there are equipment, FEMA, and planning considerations. All of these things are inquiries that have been raised that will ultimately be addressed by the moratorium itself. I think what the applicant is missing with regard to the application and his request for this exemption from the moratorium is the fact that what the village is considering here is the larger picture, the greater picture. How does this type of development impact the village as a whole? And in that regard, the village has retained consultants who are going to look into how these buildings or how these homes do impact the village community, the village character as a whole, not just with regard to 320 Murray Place or 317 Murray Place or the few individuals who submitted letters in support of their application, but with regard to how is this village going to deal with the issue of the height of these buildings being raised by the FEMA flood zone elevation and the height of those buildings being added to that FEMA flood zone elevation. How is this going to work itself out as a whole? And so I think that the applicant's presentation, 60-minute presentation, fails to address the criteria that the village board saw fit to establish in order to obtain an exemption from this moratorium. Mr. Bennett touched upon it briefly, but they're much more comprehensive than what he discussed. Basically, to qualify for an exemption, the applicant needs to establish, and this is conjunctive, that the failure to grant the exemption will cause the applicant undue hardship, which is substantially greater than any harm to the public. The grant of the exemption will clearly have no adverse impact upon the village's goals in adopting the moratorium. And that's what is really at issue here. What are the village's goals in enacting the moratorium, and how does this application run contrary to the village's goals in enacting and adopting the moratorium? And in that regard, the application, Mr. Bennett keeps talking about the height of the building. We're just talking about the height of the building. It's just the height. And the height when you compare it to the adjoining property vis-a-vis the property to the east and to the west, may not be as significant. But you're talking about, but we're avoiding discussing how does a 17,000 square foot flat-roofed structure 45 feet from the vista of the beach, or from the shoreline of the dune, or from the toe of the dune, impact or run counter to the purpose of enacting the moratorium in the first place. You have a very large structure here. We're talking about 17,000 square feet, flat roof. You're not just talking height, you're talking volume. From an aesthetic perspective and from an architectural perspective, the volume of this flat roof structure in this location at this elevation does create an architectural building that does loom over the beach, that does loom over the adjoining properties, that does loom over the interests of the public and the village as a whole, and that does run counter to the whole point of enacting and adopting this moratorium in the first place. Another point that, or several other points that Mr. Bennett raised, dealt with the prior determination of Chief Building Inspector John Foster, and the prior determination of and the comments of the Architectural Review Board. All of those determinations and all of those statements, opinions, comments, not final determinations, not building permits, all of those comments and opinions were rendered prior to this board's adoption of the moratorium. They are essentially inapplicable here. They do not apply while this moratorium is in effect. In addition, from a legal perspective, it's well settled that, even let me just get the actual, since Mr. Bennett added some Supreme Court law to his papers, I wanted to also read some law from a case that was also just in front of the Supreme Court on a different issue, but which addressed the law with regard to the building inspector's opinion letter and the comments of the Architectural Review Board. In that case, which was before Justice Barnetti, this decision just came down in October of 2014, he opined and he cited this well-settled law that a building permit issued or done in error by the municipal agency cannot confer rights in contravention of the zoning laws and is subject to corrective action, even when the results might be harsh. There are no vested rights conferred by the 2012 opinion letter that was issued correctly at the time in 2012, but it is no longer applicable here. It does not confer any vested rights on the applicant with regard to this application. Neither do the comments that were submitted by the Architectural Review Board prior to the moratorium being adopted. Again, those comments were made prior to the moratorium taking effect, and it's also worth noting that the Architectural Review Board saw fit to submit comments on the application, but not to make a final determination. And it failed, it was right in not making a final determination on that application, with the understanding that there is a moratorium that is about to come into effect that will permit the village to address this building height issue in larger scope, and to address it for the community and for the residents of the village of Southampton as a whole. So the Architectural Review Board, while it obviously understood and was sympathetic to the efforts that the applicant had made in submitting an application, basically took the, first and foremost considered the village of Southampton's considerations with regard to the moratorium, and held back on rendering a final determination on that application. A lot was raised here, so I just want to make sure that I hit all the points that I wanted to hit. Oh, and also, the Supreme Court decision that was included in Mr. Bennett's packet also predates the moratorium. And it also involves, I was reading it while he was talking about it, it also involves the very property that compelled this board to enact this moratorium and to address these issues on a larger scale for the purposes of protecting the aesthetic, the impacts of such building on the village of Southampton. And I also prepared a letter with our comments in opposition to the, to the exemption for the board. I don't want to read it into the record and take up any more of the board's time. But it's worth noting that this board, when it submitted its correspondence to the Suffolk County Planning Commission with regard to this very issue, basically explained to the Suffolk County Planning Commission that the amendments to the zoning code, maximum height regulations are necessary in order to adequately control the height of one-family dwellings and adequately balance the rights and interests of property owners, the neighborhood, and the community. We're talking about a bigger picture. And finally, with regard to the moratorium, this board is well within its rights in enacting the moratorium and essentially freezing land uses within an area to prevent the race for diligence leading to acquisition of vested rights and establishment of non-conforming uses, to allow this application to go forward and to allow this construction to take place while this moratorium is in effect runs completely contrary to the purpose of the moratorium and the reasons for why it was adopted. In addition, the applicant has failed to address that those criteria that are set forth in Section 8B 1 through 3 of Local Law Number 4. I mean, the idea that this application is the poster child for an exemption from this moratorium is laughable. And finally, I just want to reiterate that we respectfully request that that the application's request for the exemption be denied, and that this board do, as the Architectural Review Board did, not render a final determination with regard to this application, except to deny the applicant's request for this hardship exemption. He simply has failed to meet the criteria for the exemption. And I thank the board very much for your time and for hearing my comments.
Thank you. Want to clean up and I'll say a few things, or would you like to go first?
Okay, anyone else would like to speak in reference to this? Okay, Mr. Jacobson?
Yeah, go ahead, Rich. Yeah, go ahead.
Thank you. Good evening. Excuse my voice because I have something that I've come down with, but I guess I'd begin by saying...
you should just identify yourself for the record.
Sorry. Mitchell Jacobson, the property owner at the property under consideration. I too thank you for taking the time to listen to the application. I would start by saying I don't find anything laughable about our application, whether the poster child or not. It's extremely serious. You've heard from our counsel, and I'm going to try not to repeat everything that's been said out of consideration for your time. The outcome of this hearing is incredibly meaningful for me, and I'll explain why towards the end of my time in front of you. But I did want to add some thoughts that my counsel couldn't speak to. The moratorium that was passed was based solely upon concerns to the height of homes impacted by the FEMA requirements. The reasons stated relating to the neighbors, the community, and the appropriateness of the homes in their communities. You didn't want homes towering over one another, and I understand that. Please note that our home is lower in height than our direct neighbor to the west, and of similar height to those on the beach. And just to reinforce this, I've personally spent the last 2.5 weeks trying to reach out to my neighbors. I was able to reach many. Some homes were titled in LLCs, so that we were not able to contact them. But of the 14 that signed, and I only knew one of my neighbors personally, I took the time to cold call these people. I had no personal relationships. I had to search out their contacts. It's obviously the summer's gone. They're not out here. We had to find office numbers, Google searches, put a lot of time into it, either through email or through personal contact. And as you could imagine, it was a time-consuming and challenging prospect. Some of the names are very private people and were difficult to navigate to. And many of them were prominent, and they wanted to maintain their privacy. And there were a few who didn't sign who said they supported it, but they were not going to put themselves in a position of being public. But 14 did stand up, and they signed a petition with nothing on their part to gain. In our little community, the community stood up and supported the application. They did so because they thought what we'd asked for was fair, that the home was beautiful, that the height or design were not an issue, as it was consistent with others, and refreshingly, many commented that as neighbors, we ought to help and support one another. When you take a look at the signatures, please realize that each one of them took time to review the renderings of our home. They all asked for details on the home. They reviewed supporting aerial documentation and other supporting height information, and they did a lot of due diligence before they came to their conclusion. To a person, they commented about how wonderful our community is. They are the community. They clearly felt great pride and considered themselves lucky to live within the Murray Place area. These signatures took time for me to obtain. They were done thoughtfully and really carefully by each who signed. Pretty remarkable, I think, if you think about it, that 14 people with nothing to gain signed in support of this application. They were protecting their community. They were protecting their rights as homeowners. I provide this history because I hope that it's impactful for this board to know that those most directly impacted by our construction support us. Virtually nobody else is going to see the home. We're at the end of a very private road. We're located on a very isolated stretch of the beach. This is the community that's going to live with the home, and they've taken the highly unusual, and I would say courageous step to put their names on the line and to shout out that this home ought to be built. I ask you, if those who are our neighbors are rallying behind us, why wouldn't the greater community? As you know, we've spent 18 months and a lot of money in architectural fees and structural engineers in reliance on the town regulations. I'm not going to repeat it. You've heard quite enough about that. And the confirmation that was signed by the building superintendent. But I did mention early on before you that that this decision is really meaningful to me. And I wanted to sort of reinforce that by telling you a story about me and my family. I'm a pretty private person, but again, the timing of this project is very important to me, so I want to tell a story about my family. I remember actually what triggered the story is one of the people who spoke against the, or in favor of the moratorium application was actually quite lovely. A woman who spoke at the last hearing, obviously adverse to what I believe ought to happen. But she was gracious in the sense that she welcomed all the applicants to the community and urged us to be patient in an effort to see that the community would be protected. So, got a document flaw here. Bear with me. So in that effort, I wanted to take a little time to tell you a story. So my first career ended about 12 years ago. I had a great job as CEO of a growth public company that I joined when it was quite small. To do so obviously took me away from home quite a bit, which was tough for me because family is everything to me. I used to come home when I could, do homework with my son after work. I never played golf on weekends, really didn't do much. I drove him to sports events. He was a great athlete. I spent Sundays on the sports field with him. And when he was in 7th grade, one day, and I'm not sure why, I took a spring Friday off to pick him up at school and drive him to a select soccer team practice about 30 minutes from the school. The drive was incredible. We talked in a way that was very different than nights doing homework or hectic Sundays. It changed everything for me. I began to take off every Friday to do it. I also made a decision. I wanted to be around to drive him to school and to pick him up every day, and knew in my gut that it was the right thing for me to do. I worked with our board of directors, and within 3 years transitioned from CEO to chairman of the company, and from about the end of 9th grade through when he got his driver's license, I drove my son to school every day, and I picked him up. I never missed a game. I never missed a school event or a chance to talk about life with him. He's 25 years old now. I'm really proud of him. He would have been here tonight, but he couldn't get time off from his job, and fortunately I've been able to build a second career. But I tell the story because time really does matter. Time is precious. That's one thing I've always been, very lucky to appreciate, that there are moments in one's life, times in one's life that you can't get back. Couldn't get back that time with my son, driving him to school. He's 25. We all know what happens with, young people as they grow up. He works in New York City. We live in a wonderful community west of here, but it's not a place where young men or young women really go in their single days. Most of them come east, and we would really incredibly value this time together with our child as he grows up and as he enters into a family. And so while I appreciate that those who live in the community would advocate patience, time does matter. It matters to all of us, and particularly in my case, it matters very deeply to me and my family. So we have the support of the community, our little community, the Murray Compound. We have a house that is not as tall as our neighbor and in conformance with the height of others in the community. And we respectfully ask that if there is going to be ever exceptions, and maybe that maybe this is a test case, isn't this the one where the whole community has stood up and said, let these guys build a house? Thank you.
Anyone else like to speak?
My name is Lisa Sullivan Crawford, and I'm speaking for my dad, who couldn't be here. He's bouting a little diverticulitis. He is going to be 87 this month, and has been in a couple of the ARB meetings, and I worry about him. So I was listening to Mr. Jacobson, and actually it's the first time we've actually laid eyes on each other, not for lack of trying to reach out as a neighbor. Before the first ARB meeting, I had spoken with him. I just back up a teeny bit. When he purchased his property, it was through an LLC. So I tried to reach out to the realtor to find out who it was, because my job for Murray Place is I kind of run the road. I pay the guys who do the mowing and some of the trimming of the hedges, and if we need to have the road resurfaced and so forth. So everybody on Murray Place, I happen to have their names and addresses and emails and so forth. And after I have to say, it was a couple of months, I got to a man named Bob Small, who was an associate or assistant to Mr. Jacobson, who said, well, give me the information, I'll talk to him. So it was not an easy one to get in touch with. I did actually get in touch with him. He was wonderful. He paid back payments of what the Kulakundis never did and so forth, and I appreciated that. Before the ARB meeting, we again reached out to Mr. Jacobson. I had his cell phone. I called that number. It went to voicemail. I then spoke to Mr. Small, who gave me another associate or assistant to Mr. Jacobson. She said that he was not able to talk with us, but would send the architect, and she came herself. We met on the property. They talked about the type of plan. I looked at the plans at the building department to see what they look like. We saw it was a very large home, and we wanted to discuss it. The home here, his second floor that reaches towards the ocean, which is on the west side, extends 45 feet in front of my dad's property, as well as all the other people to the west. Now, I know Mr. Bennett has spoken about the old Jaffe house. I believe it's Mr. Edelman. His house right now is more than halfway through the new FEMA line, so if that house does fall into the ocean, it's not being built where it is now. It will have to be behind. So any discussion of where that house is now, it was there prior to any of the building that we did to the west. But getting back to Mr. Jacobson, we tried to reach out. We wanted to talk to him personally. And recently, my dad came to one of the ARB meetings to just voice his concern about the size of the house. He said he thought it was a very nice house, but it didn't belong in the Murray compound. It's very large, and people used to think that my father's house was very large. As a matter of fact, to give you an idea of the peaked roof height, we were 8 inches over the 35 feet when the house was being built on his bedroom side, and had to rework the whole roof line to make a double roof line to adhere to the code. So, and that's in the record of our plans and so forth in the building department. But right now, Mr. Jacobson's house is going to be 44 feet tall, and that's the 29 feet of the house plus the grade that he's going to be on. So if we are taller, yes, it's a peaked roof house, and it is within the code that was there when we built the house. My dad called Mr. Jacobson to talk to him about possibility of a discussion on pushing his house back or over, or just to have him come and look, because the ARB had requested a mock-up of what it was going to look like with the height of the house versus what their landscape plan was and how high the landscape plan was going to come up. And I have a whole text message here on my phone of, your father has called me, he didn't leave a number. Would you be kindly tell him, taking his stance on our home, that it would not be appropriate to call him. I don't have his number. Yet he was capable of reaching out to 20 neighbors in the Murray McDonald compound and finding their numbers. He's listed in the phone book. John F. Sullivan, 317 Murray Place, where he stayed. I just wanted to also, we have not sat here and said, no, no, no. We just wanted to open a conversation with the Jacobsons on the impact that his house is going to have on the community. And I hear about this petition. I have spoken to the Brodskys. I have spoken to George Kaufman, who is opposed to the home. I think the question that was brought up to these people is, are they opposed to the application for a hardship, not actually the actual building of the house? And I also wanted to say one other thing is, it's a Murray McDonald compound. Murray Place, as I'm sure you've driven down and taken a look, is one separate road. The McDonald part of the Murray compound is on Squabble Lane, and it holds true to its name because there's a lot of squabbling going on there, and a lot of those homeowners don't agree on anything, and they still have a problem with where they're going to park the car at that little beach thing and who owns what and where and so forth. And as far as I'm concerned, the Squabble people have nothing to do with the Murray Place enclave that we have. They don't drive down our road, they don't use our beach, they have their own. It's all about the people on Murray Place. So this house is going to have a very large impact, and there is a very large entrance to this home with a big driveway and so forth, that there is room for, there's a wiggle room here. And I mean, I know that he's within his rights, but there's never once been a conversation of Jacobson and Sullivan at all. And it's not been because we haven't tried to open that dialogue. So right now I would ask that
the application for hardship be denied, and at least give the neighbors who are directly impacted a chance to have a discussion and with this moratorium, which is exactly what's supposed to stop happening. I would like to ask the board to hold the moratorium up so that we can have a dialogue with this neighbor and come to some sort of conclusion that will make everyone happy. I'm not asking him not to build his house, and nor is my father, but to have a dialogue to see if there's something, because they do have this arm that reaches forward, has a front balcony that is all glass, that sits 45 feet in front of where our home is. So it literally, you can turn around and look right back inside. It's not, it's a huge structure. It is, side to side, end to end. And where there's a football field on the east, they have a whole yard and extra space. There is room to wiggle. And so I was hoping that with the moratorium, we'd be able to have a dialogue with the Jacobsons and resolve some of the height issues, the expansion issues, and it's more privacy. I know that Mr. Bennett calls it a scenic thing, but it's a real privacy issue. So thank you for your time.
Great, thanks.
Thank you.
First of all, it is our first time to meet. I would ask that you speak to your father. I did leave a message. There's a message on his answering machine, and he didn't call me back. I did call.
Okay, we're gonna time out.
I did call the number that you left me.
So we'll, okay. Okay, all right. Miss Susan.
Good evening. Susan Stevenson. I live in the Village. I don't live in the Murray Complex, but I do live in the Village, and I'm asking you trustees to stick tight to your moratorium because it was put in place to allow time to make proper adjustments to the zoning of the Village for everyone, not just for the people in the Murray Place, but to preserve the character of our village and to make the right choice so that we actually, and to prevent this kind of contentious situation from developing in the future. So it's already 1 month into the moratorium. There are at the most 5 more months. It's the winter, and I don't think it's actually a huge hardship in terms of building. But I don't think anyone that, as of right, you had a difficult choice to make the moratorium. You did the right thing, and I hope you'll do it again. Thanks.
Thanks. Anyone else would like to speak in reference to this application? Okay. So we actually have that letter from the lawyer, and I know that it's only fair for the board to be able to read the comments there. So
We just have to make more copies or something.
yeah. So and make it available to the public. So I mean, yeah, I don't know if we should take action tonight because of the written communication. Rick, what's your?
Well, we can close the hearing.
Yeah.
Whether you do a decision tonight or not is up to you. Are you talking about the letter that the attorney handed up?
Handed up, yeah.
Do we have the copies of it?
We can make some more copies right here.
So.
Yeah, perhaps we should,
Yeah.
I think, looks like John Bennett has something more to say, but perhaps we should close the hearing because we have 2 more hearings.
Right.
And then another agenda, and maybe at the end of the meeting or an executive session, we could talk about whether we want to do any decision tonight or whether we want to wait until another meeting.
I have nothing to respond to in that letter, so it doesn't bother me if you close the hearing.
Okay. All right.
And I would ask you to.
Okay. So I'm going to make a.
Do we have more copies of that letter?
Oh, I think Steve was making some copies, but.
Why don't you give one to Rick?
Yeah, Rick's got the.
Does he have a copy?
We'll make
Rick's got
some
one.
copies of the letter. So.
Okay, it looks like the letter summarizes what she orally stated to us.
Okay.
I don't see anything new in there that she didn't mention. I think everything you said orally covered what your letter says, right?
Yes, I believe it does.
Yeah, this is like a written summary.
It's a written summary. The letter addressed the things that were raised by the application that was submitted prior to the hearing this evening. I was handed this evening by Mr. Bennett, the full packet that he submitted to the board. I guess today it seemed it was hand delivered on today. So I didn't get a chance to review that packet prior to this hearing. So that letter doesn't address that packet. So it just addressed what was submitted by the applicant last week. I tried to address most of his comments.
Asking for a further opportunity to make a submission?
No, I think that if the board would consider it, perhaps leaving the hearing open or closing the hearing, it's up to the board's discretion. Thank you again.
So let's close the public hearing on this, and then give us an opportunity to review the testimony that's gone on today, review all the documents that were submitted to us from both sides, and then the next meeting be prepared to come back and make a decision.
Sounds good. Is that a motion?
So I'll make a motion to close the public hearing.
Second.
Second?
Favor?
Aye. All right, so we close the public hearing on this. Okay. All right, so we have a second public hearing here. I'm going to find my agenda.
450 Gin Lane.
Yeah, 450 Gin Lane, right. I see it.
Let me give you this.
So I'll make a motion to open the public hearing on 450 Gin Lane, LLC.
Second.
Second.
All in favor?
Aye.
For the applicant, John Bennett and Reed, 212 Windmill Lane, Southampton, New York. Some of the history to this application you're going to find is similar in certain ways to the prior application. And the reason you'll find that it's similar is because in both instances it's a tale of intelligent and responsible behavior. It's a tale of a person, two people in this instance, who paid more than $18 million for this piece of property, who went, before they purchased the property, made sure that all the laws that were going to govern what they saw as their vision for the property were such that they could be allowed to do what they wanted to do on the property. And it's also a tale, and I think you're really going to have to pay attention to this, because it's going to you're going to see what happens when that conflict between contemporary homes being able to be 27 feet high and ridged roof homes being able to be 35 feet high come before you. Because this application started out as a contemporary home that would be 27 feet high, 27 feet above the base floodplain elevation. And as a result of some comments and colloquy before the Architectural Review Board, and also listening to what the neighbor to the east, how the neighbor to the east felt about the design of the house, has changed to a very traditional home. And I'm going to also, what you're going to see today is the set of plans that you have before you, which is the current set, is nothing like the set which was the subject of plans that was the subject of that very distorted advertisement in the Southampton Press. The applicant has hired the storied, very significant firm of Choperino and Wharton, who are as good at designing traditional homes as any architectural firm in the country, in order to present to this board a beautiful, very traditional home. But I'm foreshadowing a little, because what you're going to see is, and I think actually Mr. Irving was one of the ones who pointed this out, when this whole idea of taking a look at the height limitations as they're related to construction in the FEMA zones, pointed out, was when you start pushing people towards lower homes, you end up by force, you end up with contemporary homes. But the ARB didn't like that, and neither did the neighbor, so we've switched to a traditional home. In any event, similar to the Jacobsons, our client purchased this home in October 2013, and again, prior to completing the purchase, a letter was obtained from the village building inspector, Mr. Foster, confirming the height of the structure, which would be permissible under the regulations of the village. And next is Exhibit A, is Mr. Foster's interpretation. It was a letter from my firm, which was countersigned by Mr. Foster. And again, he stated that the jumping off point, as it were, for measuring the height of a single-family residence on a property located within FEMA flood zone VE is measured from a point 2 feet above the applicable FEMA flood elevation. And then, for example, the property at 450 Gin Lane is situated in the FEMA flood zone VE 17, which requires the first horizontal structural member be located at least 19 feet above sea level. And Mr. Foster, in a sketch that was attached to the letter, demonstrates that. And in this particular instance, it was a traditional home with a gabled roof. So you can see that Mr. Foster took the elevation of 17, which is the base floodplain elevation, added the 2 foot of freeboard, which brings you to 19 feet, and then added 35 feet above base floodplain elevation, which in this particular instance gives you the allowable potential height. So again, this was a reasonable, more than a reasonable, was a responsible, intelligent approach by the homeowner, the applicant, as you can expect of someone who is spending over $18 million for a piece of property. Again, I want to remind you that this wasn't some sort of lightly made determination by the building inspector, and indeed this very letter that Mr. Foster wrote for the property at 450 Gin Lane was one of the letters that Judge Santarelli looked at when he made his determination on the 40 Meadow Lane matter, denying the request for a preliminary injunction, again noting that this had been the practice of the board. By the way, when Judge Santarelli made this decision, he was very aware of the moratorium. As a matter of fact, he speaks about the moratorium in the decision. So there's no question but that all the cards were on the table. But again, there's no question, again, that this property was purchased with a very reasonable investment-backed expectation of being able to build in conformance with an interpretation of the zoning code that had been going on for 30 years, and in terms of character of the neighborhood and impact on other homes, was the basis for, as Mr. Foster indicated, and as Judge Santarelli favorably noted, was the basis for over 60 applications for construction of homes in the flood zone. I think that's important because 60 is a very significant number. People had relied on this interpretation, and that means that over 60 homes were built under this interpretation. So you have to ask yourself, what effect does it have on the village as a whole, the neighborhoods as a whole, when these homes were built using the same interpretation? As a matter of fact, we'll be able to demonstrate to you that Mr. Smith's house, the neighbor of the of this applicant's home, Mr. Smith's home, who seems to have is really, I think it's fair to say, was the only one who who came in opposition at the Architectural Review Board. Mr. Smith's home is significantly higher than the proposed home of the applicant, and also was built under under Mr. Foster's long-standing interpretation. So, our client made sure that there was a demolition permit for the house on at 450 Meadow Lane, and in addition to that, went to the Zoning Board of Appeals as part of the application process. He went to the Grossmans, who are the principals of the application, who are here this evening, accompanied me in a very, very responsible and studied and interested manner to all these applications. Went to the Architectural Review Board, where the Architectural Review Board did give approvals for this house. We needed a little bit of relief from the wetlands. Because even though the road is in between the wetlands and the building parcel, the village takes the position that doesn't cut off the jurisdiction. So we did obtain relief from wetlands, and we also needed a little bit of relief, just a tiny bit of relief, primarily for the septic system, I believe, Melissa, from the crest of Dune. What all this results in is a building envelope on this property, although the property is a good-sized property because of the fact that there are wetlands to the north of the property, Old Town Pond, and because of the fact that the coastal erosion hazard line comes into the property. You have a building envelope that is somewhat circumscribed, so you don't have a lot of play on this otherwise rather large piece of property. Interestingly enough, Mr. Smith's home, which predates the coastal erosion hazard law and predates probably the Dunecrest setback, sits out fully in front of the coastal erosion hazard line. And that, we think, has a very significant effect on the criteria that you look at in this application, because there simply can be no way that the Smith house will be towered over by the Grossman house. Not only is the Grossman house, as you'll see, lower than the Smith house and meets this 45-degree angle, which we think the board has been looking at, but it is significantly landward of the Grossman house. But getting back to the history of the property, because I want you folks to understand that it was. It's been a long journey for the Grossmans, and as Mr. Grossman eloquently said, he was thrilled to become, a homeowner in the village of Southampton on the ocean. His reception by large majority of the village residents has been wonderful, but not necessarily so for some other folks, which is disappointing, because it should be a joyful process, not a process involved with unnecessarily expenditures and being criticized for pretty much trying to do something that everybody else has the benefit of. So we obtained letters of non-jurisdiction from the New York State Department of Environmental Conservation. We obtained a permit from the Department of Environmental Conservation for freshwater wetlands, and then went to the Architectural Review Board. At that time, the Grossmans had hired Blaise McCoy, who's a well-known local architect, to construct what I think is fair to say is a contemporary style house. That house was approximately the height of the roof. 46 feet high. 46. The original was 46 feet above sea level, and we thought, particularly in light of the conversations that started happening about height after the Grossman's purchase of the house, that would allay some of the concerns about height. But unfortunately, the Architectural Review Board and Mr. Smith, the neighbor to the east, were concerned about a contemporary house in that area. We then attempted to jigger the Blaise McCoy design to show a gable roof that did create some traction with some of the Architectural Review Board members. But at that point, Mrs. Grossman in particular made a determination that I think was quite wise and should be applauded for. She said, I don't want a house that is going to be half of one and half something else. If I'm going to have a problem building a contemporary house, I don't want to try to, by simply putting a gable on it, trying to make it a house that is traditional. And that is the house that was originally submitted to you. So subsequent to that, based upon conversations amongst all the people involved in the applications, it was determined to hire a new architect, and the Grossmans hired Shope, Reno, and Wharton, again, storied traditional home architecture, and Jerry Hooby from a partner at Shope, Reno, Wharton is with us this evening. Why don't we show the plans, show the relationship to the existing homes, and show what we've done here. I think you'll find that not only is it an architecturally very pleasant home, but it's also a home that's been designed to. It's been designed to meet the concerns that they expressed. Again, this house has been designed in anticipation of a 45-degree angle sky plane. And so both the relationship to both to the house to the east, which is the Smith house, and the house to the west, which is now owned by Halcyon Lodge. Yeah, but there's a principal involved, and we have a letter of support. We have a letter of support from the person to the west. But it's been designed so as to respect this 45-degree sky plane. The 45 degrees is measured by coming 5 feet from the natural grade along the front of the house, and then taking a 45-degree angle. But here's where the real issue, as far as I'm concerned, comes in with the moratorium. The house that was designed for this site, the original house, was 7 feet lower. 7 feet or 8 feet lower?
8 feet lower.
8 feet lower. Thank you, Melissa. 8 feet lower, but it was a contemporary home, and the neighbor didn't like it. Although we had a letter of support again from the neighbor to the west, the neighbor didn't like it, and the Architectural Review Board had concerns about it because of its location at the end of Old Town Pond. They said that's the oldest area. You all know that was the first place where the settlers were, and they wanted to see a more traditional design. But in order to achieve that traditional design, you have to have a gable roof. The height of the house has to go up. So here's the 45-degree angle, and you'll see how it minimizes the impact to the neighbors, as well as a very extensive landscaping plan by Chris LaGuardia.
Also, the height of the house was originally 30. The height of the house was originally 35 feet. What was submitted originally to the board. This house, Shope, Reno, and Morton were able to actually compress the house. So the actual height of the house now is only 33 feet. So where we could have a 54-foot high maximum ridge, we're actually 52.
So and again, an attempt was made, even though a traditional house was obviously the direction that the Architectural Review Board wanted us to go, an attempt was made to compress the house. It's just a beautiful design. I'm sure you'll agree. Now, this is a view. We'll just turn around for a second because I think it's important.
Yeah, turn around
Yeah.
and show the house is on page, so everybody gets an opportunity to see that.
Yeah, it's a great design.
To me, it's a first opportunity for people to see it.
Okay, again, this is an attempt to listen to what the neighbor, Mr. Smith, what his concerns were. He said he didn't like a contemporary house, and I want to tell you. Let me back up a little bit. Probably $350. Well, it's in my letter. The actual estimate is over $350,000 of design, engineer, landscape, all gone into the contemporary home, which was based upon a reconnoiter of the area. There are many contemporary homes in the historic district on Gin and Meadow, but the board and the neighbor didn't like the design. That's all shelved. That's all money down the drain. and a new architectural firm has been hired to try to attempt to address these concerns as we understand them. So again, we have the 45-degree angle, the sky plane, which again is an anticipation of the changes to the law, which is part of what you look at in the moratorium exemption. Then what we've done is talk about the effect on the neighboring properties. I don't know if the board members probably want to look at this, and then we can turn it around, Melissa, to see the...
We have it.
Oh, you have it? Okay, perfect.
Yeah, we do. We got it in here.
Okay. So to the extent the concern is towering over the neighbors, what do we have here? We have the revised, there's Shoprino Wharton design that's at 52 feet above sea level. The parcel to the west... okay. Okay. We all set? Okay. The parcel to the west, which was the Halcyon Lodge, and there's a letter of support from that neighbor in the packet, is 58.1 feet above sea level. That design, that house pretty much sits on top of the dune. It's interesting to note what's going to happen to the sense of place. I think the landscape looking out from the pond down there. This house has been purchased. The 436 Gin Lane house has been purchased, and the Architectural Review Board did give a partial demolition permit for that house, so that the center section of the house is going to be retained, but the glass addition to the left is going to go away. Regardless of the fame of the architect, as a lifelong resident of the village of Southampton, all I can say about that is hallelujah. I've always thought this is pretty much, excuse the expression, I hope no kids are watching, but pretty much a middle finger to a traditional architecture, which Philip Johnson, the sort of bad boy of architecture, designed. That's going to come down. And what you're going to have here in terms of changing the sense of place of this area is a traditional home. I've spoken to the owners of the house to the west, 436, and their attempt is going to be to replace the Philip Johnson glass addition with a traditional style architectural addition, which is compatible with the existing center section Queen Anne style house. You have Mr. Smith's house, a lovely traditional style house to the east, and now this wonderful Shoprino Wharton design. So I think this is in and of itself is good reason to pass this moratorium exemption. You're going to significantly change the sense of place down at the end of Old Town Pond. So again, let's look at the fact that this property is going to be far from towering over any of the neighbors. The ridge line to the Smith house is 52.3 feet, and we didn't pull that out of the air, by the way. That's taken from the village records. I want to show you. We have attached as exhibit. Let me make sure I have them. Exhibit F. And I will certify to you that these are taken from the village records, a drawing of the Smith house, which shows the ridge line at 52.3 feet, which is about 1 foot 3 inches less than the Shoprino Wharton design for the Grossman house, which again is 2 feet smaller than the 35-foot max height, or 2 feet smaller than the 33 feet. So again, not an issue there in terms of impact on the neighbors, we suggest. The other thing that's important to look at in terms of location of both of the house to the west and the house to the east, I've submitted as part of Exhibit F to my letter to you, surveys from the Smith house, and you can see by looking at the surveys that the Smith house is totally seaward of the coastal erosion hazard line. It's a pre-existing non-conforming house. And there's nothing wrong with being a pre-existing non-conforming house. This house was built before modern zoning regulations, but what it tells you is that the house is fully forward. All the habitable space on the main house of the Smith house is fully forward of the Grossman house. So the seaward side of the Grossman house, that's the closest part to the ocean, is all behind the Smith house, so there's not going to be any towering over the Smith house. Mr. Smith was concerned about shadow on his guest house and the pool of his house, but the pool is there by reason of a variance. And the guest house is a pre-existing non-conforming guest house, and it's 8 feet from the Grossman property line. So that pool is there by reason of a variance. It's in a non-conforming location, and the guest house is wildly out of conformity. And it's interesting because one of the things that I was arguing in terms before the Architectural Review Board was in terms of any effect on the Smith house with the contemporary house was that it would be lower, but the board clearly pushed the Grossmans towards a traditional design. I think it's not fair to ask one to worry about all the accessory structures on your neighbor's house if your house is not going to have an effect on the main house, particularly in this area where the building envelope is somewhat circumscribed. I believe that's more than fair, and you can't really ask the applicant to do more. And then I thought it would be helpful if Jerry, who again is partnered Schoprino and Wharton, could explain some of the thinking that went into, at our request and at the Grossman's request and directions, trying to keep in mind some of the concerns that the Smiths had about privacy, the way the public spaces were oriented in the house, and just generally to explain the house concept and design as a whole.
My name is Jerry Hupy. I'm a partner at Schoprino Wharton. And I think in your package you've got floor plans, but I think just from a verbal standpoint, what I'm going to refer to as the public spaces of the Grossman home are to the west and to the south of what their home is, and in some respects the portion of the home closest to the eastern neighbor is actually the private part of the residence. It has the master bedroom on the second floor. It has an office and a guest bedroom, which the guest bedroom faces the pond, the office faces the water. So on that neighbor's side, it's the private portion of their home. It's not the public portion of their home. So it gives them, and it extends towards the south. So it actually gives them a screen between the neighbors. There's limited fenestration on that side. The fenestration is focused, obviously, on the water. And in the guest room, it faces back towards the pond, which is an amazing view as well. So we've kind of turned our side to the neighbor to the east in respect for their privacy and in respect for the Grossman's privacy as well. Within that packet, you can see elevations, and you can see, because of the way to fit with underneath the proposed sky plane, we've got a gable where the roof line follows that sky plane and gives him essentially a roof line and a sidewall that he's looking at with a relatively low eave, as is consistent with a more traditional home.
You'll also see we've incorporated into the elevations. We've incorporated into the elevations of the home the Chris LaGuardia's very extensive planting plan. Again, is a situation where the Grossmans are as yes, the Grossmans are as jealous of their privacy as no doubt the neighbors are. Say again. But you can see that the concept behind this is to maximize privacy. And again, here's that tension that you see. The direction, understandably, I think, at the end of Old Town was towards a more traditional home. Even though if you drove down Meadow and Gin, you see plenty of contemporary homes. So I don't think it was inappropriate, far from it, or unreasonable for the Grossmans to, in the first instance, request a contemporary home. But here you see what I think is a wonderful compromise between having to build within that limited area and having to build in a way that has the minimal impact on the neighbors. Again, go back to what the concerns were that gave rise to this moratorium. You're going to be, we don't want people towering over other people. This house doesn't tower over the neighbor to the east or the west. It's lower than both of them. I would suggest to you, as a matter of law, it can't tower over the neighbors to the east or the west. And also, it's hard to design a house when all you have is the suppositions of what the village is going to come up with in terms of the modifications to the zoning law. But we're very slavish in our adherence to that 45-degree sky plane. And we specifically asked Mr. Hoopy and his associates at Choprino Wharton to design with that 45-degree sky plane in mind. There's things that you have to try to accomplish here. You have to try to accomplish a sense of place for the end of Old Town, which again is one of the older parts of the village, and therefore create a traditional design, but also create privacy for both the proposed house and the neighbor's house. So again, those public spaces, the living room, the family room, all the entertaining, we've specifically, designed to be away from the neighbor to the east. There's a bit more room, a bit more setback for the neighbor to the west. And again, both of those houses are much further to the ocean, so there's not going to be any towering over. I'm sorry, Mr. Hattrick, it seemed like you had a question.
By your thumb there, that's from the ocean side, that house right there?
Yes, the ocean side.
And the other side's from the street?
Yeah, and these are deceptive because these are straight on elevations. I think probably this is probably a better perspective to have, which is when you're down.
Oh,
I wasn't objecting,
sorry.
I just wanted to know.
Okay.
I presumed it was that way, but I wanted to be sure.
And I think, I'm going to flip back to the elevation as well. I think it's also worth noting because actually I went to three-dimensional stuff. From the street side, it's worth noting the breakdown of the scale on the house. The volumes that are there, which are traditional memory points for shingle-style homes, but they break down and they step away from the road so that as you approach this house from either angle, it doesn't appear as a large volume. In fact, from a square footage standpoint, it's actually not a very large home.
We actually, I think it's...
We reduced it 1,000 square feet from the previous design.
Square footage?
7,800, a little less actually.
And so the original one was 1,000 square feet off it from
Yep.
the original flat roof design. I don't want to forget as exhibit. One of the exhibits is exhibit number G in the packet, or at least behind my letter. We do have a letter from Wendy Hamburger, who says she is the owner of 436 Gin Lane, the neighbor to the immediate west of 450 Gin, and she's reviewed the application and she has no objection to the proposal. So
We have everything else you're showing, just don't have that.
But to a certain degree, we're being told it's not about architecture; it's about height.
It's not about architecture.
But on the other hand, your section, your moratorium says you can refer to the Architectural Review Board for comment, which means to me that is something that's being taken into account and something that people are interested in. And here and what you have here, you've essentially put the applicant in a position where there is no, if the Architectural Review Board is going to remain true to their comments, there is no option but to pursue a traditional home, which of necessity creates a taller home. So what we've done is, even in the creation of the taller traditional home, tried to keep it below that 35 feet and gone down to 33 feet. Again, lower than the neighbors. I'm being repetitious, yes, but I'm being emphatic also. Lower than the neighbors on either side. Step back probably 90 feet from the neighbors on either side. If anyone's concerned about the Grossmans from terms of a peripheral view, here's a good example in comparison to the last application. To a certain degree, these houses are all, there's a function of what's there and what's pre-existing and what the current code sections are and where that crest of dune comes in. The Grossman's peripheral view Their view is going to be straight out to the ocean, which is a lovely view, straight out to the ocean and straight across to Old Town Pond. But from a peripheral point of view, they will have two homes sitting way out, two homes built under pre-existing non-conforming situations where there essentially was no dune setback. If you look at the Halcyon Lodge and you look at the Smith House, they pretty much sit right up in the dunes. But again, that speaks to the lack of impact on the neighbors. Bruce, did you want to say anything? I know you've been involved in this application throughout, and I know
Should I go now or later?
it's your call. No time like the present, I would say. Why don't you?
Thank you.
Do you want this back?
How's this going? This one? What? Thank you. I think.
Name for the record.
Excuse me?
Your name for the record.
Bruce Grossman. I'm the owner. And my wife Diana's here as well. And I think Mr. Bennett and my professional team have done a good job of summarizing, I think, the most important facts and the timetable, which I think here is very important, so I don't want to restate what they've covered. John did mention that before I closed on this property, even though he represented the seller at the time, that I was assured that I would get a demolition permit. And knowing the history of this particular property, I did not want my first exposure to this community to be the person who got a demolition permit for this historical site. So I paid the seller an additional $300,000 to have the house, the land delivered to me, basically with the demolition permit in hand. Just to give you some thought, just to give you some perspective on what I thought the importance of this site was and the history of it, and I did not want to be the person on record for getting that permit. Now, I said this at the ARB a couple times, and I meant it, and some people chuckled about it, but I didn't think it was particularly funny. We went into the design of this house with our eyes wide open and very flexible about what path we would take, whether it be contemporary, traditional. We were very open-minded. We concluded that the best path for us and for our neighbors was to construct a contemporary design. We thought it would be less obtrusive. We thought it would be lower. And it wasn't that we had a strong preference for that. We thought it was nice. A lot of the things that the architect said about Mitch's house were things that we felt about our original design. But much to our surprise, there were people who spoke out against that house. And also much to our surprise, the ads that were taken out in local papers to rail against our house, which distorted really what we were doing. Obviously, between that and some comments from the ARB, and by the way, that process is not the most visible process. It's opaque. It's not always clear what we should be doing. We made it very clear we were receptive to making changes up until a certain point. But we were very surprised because throughout the whole process we analyzed the breakdown between traditional houses and contemporary houses in the district, and went up and down Meadow and Gin and saw lots of contemporary houses. Actually, there's one that was just approved not too long ago that you're all familiar with. And there's actually one that's being built right now. So why would we think that we didn't have the right to build a contemporary house that everyone, even at the ARB, said was extremely beautiful and tasteful? So having said that, we've taken our probably close to $400,000 of architectural and other professional fees and have basically burned them. And in response to the community, in response to our neighbors, in response to anyone who had anything to say, we've said, we'll burn our design, we'll start from scratch, and we'll build a traditional house that's suitable for this piece of property. We've cut the size, because even though it wasn't big before, relative to the size of the property and what we paid for the property, we've cut it. And we've made it as low as we possibly can, given that it's now a traditional design. And I don't know what else we can do. And talk about hardship, we do have a limited envelope, and John told you what we paid for the property. And I can assure you that if we're restricted to building a, 4,000 square foot ranch house on that property, what's your guess as to how much money we're going to lose on that investment? I say our investment drops by maybe 50%. So we're at a loss. Time is of the essence. I agree with the comments Mitch made. So I refer to him as Mitch because I've known him a long time. Time is of the essence. We've owned the property since October of last year. We've already missed. We were supposed to be in the ground now. And frankly, I don't even think we should be at this hearing because I don't think it should have ever gotten to this point. We were well on track. We got through the zoning board in June. We made our first presentation to the Architectural Review Board shortly thereafter. And had this gone in a way that made sense to us and that was visible, we would have had our application approved, we would have broken ground, and we would have been in front of this moratorium, and this would not be affecting us. But because of this whole process, and the ARB slowed down a lot as this moratorium approached, we've been dragged into it, and we are at a complete loss. We've done, I don't know what else we could do to demonstrate our flexibility and our interest in satisfying our own needs, but also the needs of the community. So I appreciate your time and your interest, and I'm happy to answer any questions that you might have for me or my wife at this time. If not, we would appreciate you granting us an exemption, yesterday. Thank you.
If I could just, thank you, Mr. I think probably the ultimate show of the Grossman's flexibility is not only the probably 6 hearings that we went through in front of the ARB to try to divine what it was that they wanted us to do, in effect, but also the fact that it's essentially taken about $400,000 worth of design fees and burned them and hired a firm to design a very traditional and beautiful home. I think this picture tells a lot of the story. And what it shows you is the Smith House, which is the house to the east, and the site. Whose site? I'm sorry. Sorry.
Yeah, good question.
Excuse me? Yes. And I think this tells a lot of the story. In terms of potential impact on the houses to the west and to the east, well, the neighbor to the west, understandably, has given us a letter of no opposition, despite the fact that, guess what, there's a guest house and a garage in a non-conforming area, similar to the house to the east. What you're looking at, the Grossman house will be the seaward part of the Grossman house will not come past as a tad behind the middle portion of the existing house on the property. And what does that show you? That shows you that both the house to the east and the house to the west are significantly further to the ocean, and therefore will not be impacted whatsoever by the construction of the Grossman house at 33 feet above the base floodplain elevation. We've also demonstrated that there was a concern about privacy, and the reason I wanted Mr. Hoopy to talk about the way the house had been designed so that that the more public areas, so to speak, the areas for entertaining, the living room, dining room, which are the west side of the house, was to minimize the impact on the Smith House. The Smith House was constructed at a time when the Architectural Review Board I don't think, probably was originally constructed at a time prior to the existence of the Architectural Review Board, but what you will see in terms of privacy on the Smith House are many elements that the Architectural Review Board would simply not allow if the application were before them now, which is numerous balconies which do look down into the Grossman property. To be contrasted is the very studied effect by the Grossmans and the Grossmans architect to minimize any sort of that type of improvements on the Grossman property. Melissa?
You change the tape there?
John.
Okay.
Yes.
Exactly where is the house starting?
Okay. Okay.
What's that,
Go
Charlie?
ahead.
Oh, okay. The proposed house will, the seaward side of the proposed house is essentially where the seaward side of the existing house is. And the way I can tell you that both of these homes are in front of it is that the coastal erosion hazard area, as is shown on the Smith survey, which is part of the packet, is just about at that portico. On the front end, it appears to be a portico. I think it's like some architects call it a porte cochere, but it's not a classic porte cochere. But in any event, that's where the coastal erosion hazard line commences, and all of the Smith House is seaward of the coastal erosion hazard line. With the exception of some of the septic system, all of the Grossman House is landward of the coastal erosion hazard line. So the house will be just about here. I mean, I'm indicating the front.
The survey that was submitted as part of the original application, the footprint has not changed.
In terms of its
Correct,
proximity to the
proximity
ocean.
to the ocean. So really, the footprint has not changed, and it's what he's saying, where the existing house is here to be demolished, it's pretty much where your 100-foot setback is, which is also see where the coastal erosion is.
So again, that's a great visual display of the lack of impact. Back here, these two houses out front, both taller.
All right. Anybody from the board have any questions or comments? Anybody from the public?
Mark, before you go on, I just have a technical comment. The plans that Melissa filed today, I'm just seeing.
Yesterday.
Yep, yesterday. But you're just seeing them.
You're seeing today, filed yesterday.
Yesterday or today,
Right.
whatever.
Just want to make sure they were the right ones. That's
We're
all.
just seeing them
right.
for the
That is
first
accurate.
time.
Yes, that's accurate.
And maybe I'm missing something, but the original plans on the elevation sheets, they showed on those sheets the existing natural grade, the FEMA +2, the top of the ridge. All that elevation data was on the actual elevation sheets.
It's on the side plan that I believe was not submitted.
I don't have a plan that shows all that elevation data.
It's actually in the packet that Mr. Bennett dropped tonight. It's exhibit.
That's what I'm asking.
Yeah, it's exhibit I. It's the very back, right?
One of these exhibits?
Correct.
Right.
Exhibit what?
It's the last
Right.
I.
It's exhibit I, but why don't we submit
We can submit this to the record.
submit that?
Yeah.
Exhibit I.
Okay, well, Exhibit I is not legible.
Yeah.
Exhibit I, we can submit 2 full-size copies.
No, we'll submit this full-size copy. I can read it, but I'm cheating. I have
Take
reading
them or you want to
glasses.
hold them?
We'll get that to you.
Is there any reason why you can't put it on the elevation plan? On the elevation plan?
This is
North elevation.
the north elevation.
Street view, this is zoning, it has both.
Okay, when it's not legible, I can't tell what it
No,
is.
we just submitted full-size.
I don't know.
That's right.
We just submitted full-size sheets here.
Let me just get back to this.
No, here's-
Coming down.
Make sure it has what you need, Rick. I think on the right hand, both the right and left hand side.
It has average existing grades and the FEMA information.
Oh, okay. All that data is on there legible.
There you go.
It wasn't on anything that I had that was legible.
I understand. I got it.
So,
I agree.
question, comment withdrawn.
All right, anyone else like to make comment in reference to this? There's a lot of information that's been presented yesterday and today and tonight. And, you know, personally, I'd like to. So, Bachman, yeah, come on up.
So much noise.
Can't hear you. Yes, my name is Bruce Bachman. I live at 660 Halsey Neck Lane in the Village, and I'd like to relate a little history here because I thought what Susan Stevenson said was spot on. This is really about the moratorium. It's not about the architectural characteristics of any building that may have been caught up in it. It's really about, did we create a moratorium for a very good reason, which I believe we did? Did we take enough time to consider it? Yes, I think you did. Did you put the burden of solving the problem, at least we hope we will, first of all, in the hands of the Planning Commission to come up to recommendations as to what we should do for the good of the village? And it's always unfortunate when someone gets caught in a moratorium, but that's the essence of owning real estate. There is always a risk the law will change, and that you'll basically have some disbenefit, I guess, from owning a real estate and getting caught up in a law change. I feel sort of I got that treatment when I bought my house. There was no FEMA. Number of years later, along came FEMA, height limitations, height restrictions were much higher. A house got built next to me. It looms over my property. I had no recourse. I couldn't say that was to my disadvantage. Just couldn't do that. The second thing is, with regard to the moratorium, and I'll paraphrase, although I probably should have it written specifically. There were three things that you need to do to get an exemption. You have to prove undue hardship. And, you know, if you look, I'm not a lawyer, but undue hardship, I understand, is a very, very hard thing to prove. This hasn't been discussed at all tonight. You also have to prove that that hardship is greater than the potential loss to the village. That hasn't been discussed at all. And there's been 2 hours of discussion, which basically should have been, or should be eventually, in front of the Architectural Review Board, not in front of this group, unless those first two conditions are satisfied. And I know why it hasn't been presented with undue hardship, because you can't prove undue hardship in this case. In the context of the values of these properties, the expenditure of $400,000, which I don't want to trivialize, is not really significant in light of the potential harm, as stated into your letter to the Suffolk County Planning Commission. The potential harm to this village, I think you used the word impact, will have been the harm of sticking with the regulations we now have them. So I say, please, look at all three clauses, demand proof of all three conditions, and don't get caught up in this massive red herring about architecture. Thank you.
Anyone else from the public would like to speak right now?
Can I just respond directly to that?
Sure.
If I may. That's the red herring here. First of all, I had to show you the architecture of the building. I had to show you the elevations to demonstrate, contrary to Bruce's claims that I didn't demonstrate it, I had to show you and to demonstrate that there was no impact to the neighbors. How else would I have shown you that? The statements, you shouldn't grant any exemptions because you have a moratorium, is nonsensical, because that's why you have an exemption application. And indeed, I have demonstrated all of the criteria that's necessary. I've demonstrated that there's not going to be any impact on the neighbors. So I'm not going to tower over the neighborhood. The neighbors are far away. I've tried to anticipate what you're going to put into this law, and I've showed you how I comply with the 45-foot sky plane requirements. That's hard evidence that I have looked at the moratorium exemption standards and met with them. And if you're going to tell me that I have to bring 5 appraisers in here to tell you that if you pay $18 million, more than $18 million for a house, to be told that you can build a one-story house on it, I think it's self-evident that that is a significant amount of hardship. The law is quite clear. If you zone a property to in effect, slice the value of the property, then you in effect have taken a good deal of the value of the property. It's not just the $400,000 in flush down the toilet professional architectural land design fees. It's the effect on the value of the property. I don't think anyone could seriously suggest that any owner of this property who pays this amount of taxes and has shown this amount of adherence to the wishes of the Architectural Review Board and the neighbors' wishes as we see them, I don't think anyone would suggest that that person should have to build a one-story house. We've tried to do a contemporary house that would have been 8 feet lower. We realized that the Architectural Review Board and the neighbors didn't cotton to that house. Where else would you have us go? What else would you have us do? We didn't go to the max height limit for a traditional house. We tried to compress the house, but there's only so far you can go and comply with the ratios that are required for a gabled roof house. These are not houses with 12, 13-foot ceilings. Far from it. This is a 7,800 square foot house in the estate area is not a big house. And people may raise their eyebrows at it, but that's what drives the value and that's what drives the tax base.
My name is Jeff Bragman and I represent Neil Smith. I just wanted to say on the record that we would appreciate it if the board would keep the record open. We haven't even had a chance to obtain these materials, some of which were submitted tonight, and we'd certainly like an opportunity to present some comment on it at your next hearing if you would keep it open. Thank you.
Any further comment from the public? Jay?
Thank you. My name is Jay Deasing, and I'm president of the Southampton Association and a resident of the Village in the Old Town neighborhood. I just want to make one initial observation. I think that we should, going forward, make sure our building inspector isn't making representations for real estate transactions, because I think that that is something that we shouldn't be in the business of doing. So I hope that we reconsider the policies there and look at what's happening, because that clearly is something that is coming back to haunt us. I think also it's important for you to remember that our neighboring villages have a maximum of between 40 and 45 or 44 feet above sea level for building heights in the flood zones. So what we're looking at as potentially changing our code through this moratorium process could conceivably, even if we go to the maximum of what our neighboring villages do, would be 44 feet above sea level. And so, again, I think that's something that should be a consideration. And obviously, with this particular house and the one that's coming up, they also are in the historic district. And so, in spite of what the applicants may have initially been told, the code is fairly specific about adhering to and respecting design features of the neighborhood. And I think that perhaps some of the issues with the ARB would have been solved if that code had been adhered to. So thank you very much.
Jay? I have to rise and object to this because it's a mindset that drives me crazy. The building inspector wasn't making representations in furtherance of a real estate transaction. There is a cast of people in this village who don't like the fact that the village building inspector does his job, which is when a taxpayer and a homeowner goes in. I didn't even know you were here, John. That brings me up. Yeah, good for you. Because when a taxpayer or a homeowner goes into the village building inspector and says, "What can I do on my property?" it's his job to inform the person of what they can do. Some people don't like John Foster because he doesn't say no all the time. He looks at the law, as he did in many of these cases that the judge approved, and says, we've been doing this way for 60 applications that he's handled, and for 30 years. And if you want some building inspector that suggests that all he's going to do is say no, that's certainly not a municipality that I want to live in, and that's certainly not a building inspector that you want to have and hire. It's his job to inform a taxpayer and a homeowner of what the rules are. And I think he's been a damn good building inspector, and I don't want to sit here and have him criticized constantly.
May I speak? Yeah. I'd just like to say, if Mr. Deasing would mind his own business once in a while and not dig so deep, if he's referring to the real estate license I had some time ago, I don't have a real estate license anymore. I'm not in real estate business. When it comes to people coming to address what can and can't be done, I have to handle real estate people all the time, attorneys all the time, local citizens, as well as I'm a citizen also of this village. I can't be any fairer than I am, and I do say no a lot, and a lot of people don't like that. I have attorneys come at me because I say no. I have attorneys because I say yes. It's a position. I follow the codes, and as I see fit, that's how I address every property and everybody in this village.
You have a tough job, John, and I think you do a good job. Yes, Mr. Smith.
I think there might be a pretty... Sorry, yes, Neil Smith, 466 Gin Lane. Thank you for allowing me to speak as ever. I think there might be a very simple solution to this little dilemma that you have here. I actually did very thorough due diligence when I bought my house, and I looked very closely at the file for 450 Gin Lane. And I think Bruce might be mistaken slightly because in that file, the demolition permit was actually granted in 2009, unless he was part of that. But one thing I didn't find was this letter from the building inspector. What I did find was even photocopies of phone calls, so-and-so called, Melissa left a message, please call her back. All of those things are copied and are in the file. So, you know, if a letter like this is written, it's real simple. Just include it in the file, because if it's in the file, then, you know, everybody can see it. And I think that's probably a simple solution to, you know, what might be a difficult problem.
I do have to say that we have the files here, and I've seen letters like this in files, and I don't know if... Yeah.
Anyway, sorry to interrupt. I think this is off the top topic.
He does put those letters in the file. So, yeah, maybe it's, I don't know. Okay. All right. Any further comment in reference to this? Melissa.
Melissa Dedovich, Peconic Environmental. I just wanted to get on the record that our clients have really been doing their due diligence. When the decision was made to change to traditional, as you know, designing a house is no small feat. I did provide to Mr. Bragman, unfortunately, when we actually submitted to you, I did email him a copy of the file. I apologize to everybody, but Jerry can only draw as fast as he can, and he was just retained within the last 2 weeks, and I think they did a wonderful job within the last 2 weeks, and I just wanted to bring that to the board's attention. This has been a project that our clients have been involved in for many, many months. This isn't just the time in front of you. It's been, again, the time in front of the DEC, the time in front of the ZBA, the long time. We've had 6 hearings in front of the ARB, and a lot of financial hardship. So there is a financial hardship if they have to wait another couple months until they can commence building.
All right. Since we've got just had the application dropped off and changes and stuff, why don't we keep this hearing open till the next hearing? That'll allow us an opportunity to review this information and review what's been said here tonight, and then we'll yeah, some substantial changes and. Okay.
No, you should keep it open and adjourn it. That request is reasonable.
Yeah.
I just wanted to mention that your next meeting is Tuesday, November
25th.
Whatever the date is. It's just before Thanksgiving.
Yep.
I will not be here. I'm leaving for a family Thanksgiving thing before that
Okay.
day. So.
Okay. Well, I mean,
hearing that night, I won't be here. I just
okay.
wanted you to be aware of that.
Right. Okay. All right. We're going to continue. We'll continue the hearing that night, and we'll talk beforehand. Okay. So make a motion to keep the public hearing open until the next meeting on November 25th.
Second.
All in favor?
Aye.
Aye.
Thanks for your time.
Okay. Okay, so we have a third one here. So, so I'd like to make a motion to open the public hearing on 22 Gin Lane.
Second?
Second.
In favor?
Aye.
Aye. We'll wait till the, yeah, we'll wait till the room gets cleared here, so.
Give us a minute to set up.
What's that?
Can you give us a minute to set up?
Oh, sure, yeah. Yeah. Okay, I'll get a sugar crash here, and I'll pass it down to Rich will probably eat the whole cup.
Is that a clean napkin or a dirty napkin you just threw at me?
It's a very dirty.
We're pretty, I'm good. Are you good with water down there? Thank you very much.
Yeah.
Do you want any sugar? Sweetener?
No, thanks. Very nice.
Okay, may I begin?
Sure.
Okay, Anthony Pasca of Essex Hefter and Angel for the applicants Beck and Alex 22 LLC.
Actually, could we just shut the doors there, so, yeah.
Anthony Pasca. The LLC is, obviously, a family owns this property, and the Ayers family, Sarah and Charlie, are the owners of the LLC, and Sarah is here. Just wanted to point that out. And also here with me is Randy Carell, who is the architect on the project from Robert A.M. Stern Architects, and Melissa Dedovich from Peconic Environmental. If you don't mind, before we begin, I'd like to hand up a few things so that we're not interrupted throughout the process. And I'll tell you what I'm handing up. I'm handing up several copies of 4 letters of support, 1 email and 3 letters from the immediate adjacent properties. So the property across the street, the Stern property, 2 vacant lots, 20 and 24 Gin Lane, as well as Mr. McKnight, who owns the property just to the southeast. And they've all submitted letters after having seen the plans in support of the application. I would also like to hand up several copies of, it's basically manageable copies of all the plans bound together, which I think should make it easier for us to go through.
We got the big ones.
Yeah, they're harder to look at, so the...
Tough time getting these things in a folder.
Yep. And I think these, you'll find these
But they're all legible.
We try. And we'll go through some of those today, obviously, and we have some bigger markups, but at least you'll have something to look at. And then the last thing I want to hand up are several sets of a chart and aerial photograph that Peconic Environmental prepared. It's basically a neighborhood analysis of the immediate area.
Was
it extras?
I'm sorry.
Yeah, I don't have room in my folder for extras.
We'll keep the extras. And the neighborhood analysis we'll talk about a little bit too, where she did some analysis, obviously, of the existing neighborhood and the ridge heights and some of the FEMA standards that apply to those properties. This property doesn't have the history that the other 2 had. In fact, the Ayers family bought this property almost immediately before your moratorium hearing started in August. They bought the property at the end of July, and which at the time was not subject to moratorium, and they purchased, at the same time they purchased this property, which I'll tell you why it becomes important in a little bit, they also went into contract to sell their property. They have been they've owned a property on Pheasant Lane for 18 years. They've been living there for 18 years. And simultaneously with purchasing this property at 22 Gin Lane, they entered into an arrangement to convey their Pheasant Lane property, not immediately, but after about a year and a half, they're going to be obligated to convey that property, which would give them time to get through, or so they thought, through the construction process on this property in 22. So I think what I'd like to start with you have a site plan in this packet, which you've already seen before, but it's critical to understand. We want to talk about hardship and unique hardship here. It's important to understand that this property is constrained in certain ways. Right? Aside from it being a corner lot, really has this strange corner lot shape, it's also got an unusual building envelope. There's if you can see the dashed line in this building envelope here, the building envelope basically triangulates up to the northeast, all right? And it puts with the front yard setbacks on both sides, the 80-yard setbacks, and then this rear yard setback, it creates a very limited building envelope for this property, okay? So there's not a lot of, there's really no other location for a home on this. And the other important part of this site plan is you'll see going down the middle is the division line between the FEMA AE14 and AE12 line, okay? That is a critical issue that's come up in the design of this property, this house, because the way FEMA works, if you are partially in one district, you are required to design the house to comply with the more restrictive. So the entire house has to be designed to the AE14 standards, not the AE12 standards, even though a big chunk of the house is going to be in the AE12. So it's 2 feet difference that was required. And what we're talking about in this case is a 2-foot, you want to call it a variance, you want to call it relief, but when you look at the elevations, and the architects have not designed a 35-foot tall traditional house, they've designed a lower profile 32-foot tall traditional house. But even with the 32 feet and with the required AE14 compliance and the extra 2 feet, it takes us up to 37 feet above the average natural grade. So what we're here about is that 2 feet. 2 feet that's caused because we're partially in this AE14 district, not the AE12. The 2 feet is, and I think part of the reason we have this model here is to show you really what part of this house bisects that extra 2-foot plane, okay? So we have, your moratorium gives us the 35-foot grace, which is so on this house over here, there's only one portion of this property that bisects that extra 2-foot plane, and that is that sliver right there, okay? Everything else on this model complies with the 35-foot plane. So your gables that go, or we say that's north, south, the big gables in the front, those are all at the 35-foot mark or under, okay? From the Meadow Lane view, which would be really over there, you can see that the 2-foot triangle that actually pierces that 35 feet, maybe if you look at the elevation drawings also, which are in your packet. What we're talking about, take the east-west ones. I think, Randy, you pointed out to me that your 2-foot piercing hits about the second shingle down from the top of that peak. So if you want to look at a little bit of a triangle, the rest of this lengthwise does not pierce. Those are the gables that are on the front of the house. It's this tiny little triangle here. Okay, so we are talking about that little 2-foot triangle that's caused because of the AE14, AE12 split that forces us up 2 feet, and that's really why we're here. And we consider that, and we hope you consider that, a minimal requested relief. When you compare it to, as we talk about hardship, the Ayers family, well, anybody who's engaging in a construction project like this knows that timing's everything. And you have to plan your project, you have to get it designed, you have to get construction going, you have to get it done hopefully before the summer season, that's when people don't want to be dealing with construction. In order to do that, this extra 6 months, 5 months, whatever you want to call it, would be a devastating hardship. All right, they are losing their existing house by this time next year, and if they have to wait the other extra 5 or 6 months to get past this moratorium, that is a devastating hardship from that perspective. We have looked at, when you want to talk about balancing, in essence, balancing the hardship against the whatever detriment, if any, you can see on the public. So remember, we're talking about the little 2-foot sliver. I know you want to talk about designs, but the family is very respectful of the notion that this is, we could call it an iconic location. Everybody knows this location. And the family has really, they're proud of the fact that they've gone to, I won't embarrass you, but very talented architects. Robert A.M. Stern, I think their reputation precedes them. I don't have to embellish on that. And the design you'll see all over these plans, everybody on our team feels that this is something that not only is the family going to be proud of, but the village is going to be proud of to have at that iconic corner. The neighborhood analysis that Melissa prepared, it sort of shows that this area, have that out there, Melissa? It shows that this area is a little bit all over the place in terms of trying to determine what the character of this particular neighborhood is. We have, and most of these were, when the 2009 changes to FEMA came in, before that, most of these homes weren't even in a flood zone. They were in the X-flood zone. So you'll see on the right-hand side, that's the prior FEMA zone for all these houses in this area. All of them were in the X-flood zone. After the 2009 changes, you'll see the column, the second from the right, shows where all these properties now lie. And some of them are in the 15, 14, and 12 AE flood zones. The middle column is from the best that Peconic Environmental could do going through all of the village's files, trying to find out where all the elevations are and relative to the current, so that they're all using the same datum. A couple of them could not be determined from the building department files, but you'll see that the ridge height elevations range from as low as 36 above sea level to 64.5 feet above sea level. And that's not including 12 Fairley, which we couldn't determine, but has, as you know, when you want to talk about the idea of towering over neighbors, a lot of these homes, you take the view back from Meadow Lane and look east, you can tell which homes tower over the neighbors. But that's part of this community, and they've been like that for a long time, and no one's questioning anything. But the proposed ridge height for this home is going to be at 48 feet above sea level. So, and remember, it's that, take the look back from Meadow Lane, it's that little tiny triangle that's going to be in that area between 46 and 48 feet above sea level where we actually need relief from this. So the idea of towering, I think, is not part of this calculus in this case. I think that's as clear as any application you've had before you today. And we also did include in this package a sky plane diagram, because that is something that's come up. And I think you can see from the sky plane diagram that this is not even close. Okay, so if you do end up going in that direction, we are, I don't want to say miles away, but in relative terms, we are a long distance away from coming close to the sky plane that you might be considering imposing. So that's where we are. I don't want to make this more complicated than it is. We spelled all this out in our petition. The family is facing a hardship that compares to what we would consider and hope you consider a de minimis impact on the community. This is going to be a house that the community is going to be proud of, the family's definitely proud of, and we're asking for the exemption from the moratorium.
Okay. Do you have any,
Do you have any questions?
from the board members? You guys have any questions for these guys? Do you have any comments from the audience? Okay. I'm looking at you three, because...
We all have come to an agreement over here.
I mean, it's, I think they're 35 feet and 2 feet, and it's really, okay. So why don't we close the public hearing on this? I'll make a motion to close the public hearing on 22.
Second.
All in favor? Aye. And if you want to take action on this, this is, the application is not changed. We've not had any further input from the public on this. And
No, I
doesn't have any comment.
think they've addressed all their concerns, they've addressed the public concerns. We've looked at the site and where it impacts.
Yeah.
My thinking.
I mean, this actually is the perfect
Poster
application.
child?
No, you can get any better than this.
Poster child for exemption, is that what you're trying to?
Yeah.
Is that what you're trying to phrase? Maybe this one is the poster child?
Maybe this is the poster child for example.
If we were.
Well, the other thing is, if you look at the elevation of the houses that will go up next to it and around it, they're the same.
They're the same. They're all the same. Everything's the same.
Based on their elevation, their FEMA zone, it's the same.
So, and
I think this is the poster child of exemption.
So
It's
I'd
fairly
like to make,
clean cut.
I'd like to take action on this application tonight, so.
Want me to order simple
Yes,
resolution for you?
Yes, simple resolution,
Okay.
please.
Based upon all of the information presented and upon the board's inspection of the neighborhood, we find that this application meets the standards for an exemption from the moratorium, and thus we grant the exemption application.
I'll make that motion.
Second.
Have a second. Little discussion.
Aye.
All in favor?
Aye.
Aye.
Yeah.
Can we proceed immediately to the ARB now?
Go to the ARB. Yeah. Okay.
Thank you for your work.
Some more extra copies
Hey,
you
you
can
want-
take?
What's that?
Some advantage of being last on that one, huh?
Beautiful home.
Want me to actually take it?
A nice model, by the way.
Leave out the bit about the poster child.
Left it out on purpose. I didn't want to overdo it.
Okay. Do you guys want to take a break, or you want to continue to go?
Let's fire it up.
Fire it up. Okay. Let's go.
Get going. One communication
What
to
is
the
it,
board.
10? 9.
It's,
That's an hour
9
fast.
o'clock.
Hey, what's up
I
with
was
that?
like thinking when I was looking at 8 o'clock, I was like, it's already 8 o'clock.
Okay,
I'll be home.
Okay. Let me make a note to do that.
you mind? I just want to clarify, because I certainly didn't mean to attack, if anyone thought I was attacking the building inspector. I really just was concerned for the village that, these numbers are so big, and somebody buys a parcel for $8 million or $10 million or $15 million, they're going to put a $15 million house on it. And it seems to me that I think definitely he does a great job giving people feedback, but to put something in writing for, an applicant might put us in a tough situation.
Here's what I'm going to, and I didn't want to respond to you on that. And I just recently bought a building in West Hampton Village, and I went to the building inspector there to talk about the use that I wanted to do. And one of the things I needed was a letter from him, which talked about the zone. My mortgage company wanted it, and I requested it before I ever bought the building. He put everything in writing, and I think it's pretty standard that people put in writing. And he didn't step. He related what the zone was, a Hampton commercial piece, what I was allowed to do in that zone, and that was the letter that I needed for the mortgage. And I think Mr. Foster does that frequently for people, the same way Paul Houlihan in West Hampton Beach did it for me and many other residents and stuff. So
I think as long as there's a process and is there a disclaimer? Was there a disclaimer that they put on that?
Well, I don't think he didn't need to put a disclaimer, because he quoted exactly from the zoning code, and he attached the zoning tables to it and said, this is in this district, these are the allowable uses that you can do, this is the height and the setbacks and all the requirements. It was purely everything that came out of the code. And I think that, when I read Mr. Foster's letters, I think that they're very similar in content to what Mr. Houlihan put in place for me, and he's done that for other people. So I think it's a pretty standard practice for building departments to provide that information to potential property owners that reach out to them. And I made an appointment. I went in and sat down with Mr. Houlihan beforehand, and so it's there's a lot of activity in the building department. That's one of the reasons why when we met with him, he said, look, you're going to shut down for 3 days a week for a couple of hours in the morning, to allow you an opportunity, no phones, no visitors, anything, to review applications, to make sure things are in place, because the volume is so great in here. We also said to him, we said, look, when the applicants come in, they were trying to get everything onto the agendas. And he said, no, take a month. Tell them it's going to be a month before it even hits the agendas. Those are two things that when we met with them, trying to give them relief, and we saw them. We had a $26 million property that came in here and an $18 million property. I personally can't even conceive of paying that kind of money for a second home, or a third home, or a fourth home. That's me. And
We're throwing away $300,000 on plans.
$300,000 away on plans
on plans
because you wanted to conform to the neighborhood and stuff. It's a lot of money. It's a lot of pressure. It's a very difficult job. I think that John and Chris and Ten, these guys, I think they work hard and they do the best they can. And there have been incidents where they've missed things. And every time when they miss things, those applications, Woolley Street, for example, the Pyramid Law on Woolley Street. I keep going, that's, I think sometimes when we look at sometimes the parking stuff, these are things that we've emphasized with them. And that's, that's, people were saying, well, we're looking at height because of the flood zone. The reality is we're looking at height across the entire village because we don't have a pyramid law on properties that are over a half an acre. And I think that if you drive down some of the streets, you'll have half acre, three-quarters of an acre, a third of an acre, and an acre. So then you'd have 4 properties there. 2 of them don't fall under a pyramid law. So those houses end up towering over the houses next door, invading privacy and all of it. So I think there's a lot of great research. It just doesn't apply in the estate section. It just doesn't apply with the FEMA component. And it's really, I applaud Mr. Bachman for bringing it to us. We've done it, and having us study this. And we're trying to get this done as quick as possible. So, yeah, I can understand why Mr. Foster got upset with the comments, and you know, and, but what he does by those letters is not out of the norm with the building departments that I've dealt with personally.
on West Hampton Beach?
So, excuse me, yeah, just come on. My letter, the question is, was my letter on what? Yes, my letter was on West Hampton Beach Village Building Department letterhead that stated what my zones were. They provide it all the time because they're legitimate questions.
No, I agree, and I just think that there ought to be a process for that, and there probably, I mean, let's face it, you can't watch an aspirin commercial without a 3-minute disclaimer at the end in speedy talk that you can't hear. You know, they tell you it may cause everything from, you know, immediate death to what have you. So I just think that, you know, we might want to look and see if that's something we should update, just to have a disclaimer on there that says, you know, while you can rely on this as being correct as of today.
Actually, I think there is a disclaimer on there.
So if there is, that's...
I think that, I think we have a copy of that letter in here somewhere, in the application. Let me just, on, what was that? That was 320 Murray. That's what that was. Exhibits on 320 Murray.
I mean, I see what you're saying, like the things we have on financial stuff, you know, this does not indicate any future or guarantee results.
Right. I mean, just don't want to box you in because people are paying a lot of money for these properties, and if they can't do what they thought they could do, they're going to take legal action.
I respect what you're saying here, and
it's not about the job that John was doing, just that you know, that's something that I think could put the village into a tough situation.
Disclaimer might be smart to just tell them to rely on their own attorneys or.
Well, again,
tell them what you think.
Like stuff we see all the time.
Yeah.
Past returns do not guarantee future results, type of thing.
I was going to say, if I could just for 2 seconds, as a land planning professional, Melissa Dedovich, Peconic Environmental, I deal with all the villages, all the municipalities on the East End, and then some. And I would say that all of the building departments I deal with do, as Mr. Epley said, provide a written outline of what you can and can't do. When you go for the building permit is when you get reviewed. And that's when you really, but this, the letter of the law, the letter of the code is provided if you request it.
But in the 2 cases that came before you, the quote comfort letters, these letters that were written on attorney's stationery, they were not written on the building department stationery.
Yeah, I just saw that on
And one of them has the date crossed out or something. I had never seen anything like this, but I was shocked, actually, but I don't know what I'm talking about this, really, I'm not a lawyer, that it was on attorney's stationery, and it said, if you agree to this, sign it, stamp it, and date it. I don't know which one. The first one.
Yeah.
And I found that to be improper in my head. So that if the building inspector is going to tell people what they can do, he should put it on the building department letterhead and not be at the. It looks improper to me. I'm sorry, and I'm sorry if that's insulting to the building inspector. But as a member of the public, I find that to be pretty hard to swallow. Sorry.
No, here it is. It's on. Go for it. It's great.
Oh, okay.
There's another one. The other case, too.
Well, it's 2 John in it. John signs who concur with it and stuff. So, yeah, some good points and you know, discussion. I'm sure he and I will speak tomorrow. I'm sure he and Michael will speak tomorrow. Yeah, look at this. You know what? None of this stuff is easy, and it's really not. So, can only imagine how the ARB and the planning board and all these guys, the volume of paper that are coming in. So,
Evidenced by
yeah,
this.
wow.
Okay. Can I make one comment quickly?
Yeah.
Mark, after we went to see these 3 parcels last week, the 4 of us, Michael and yourself, excuse me, Nancy, yourself and I, but you and I had spoken in Village Hall beforehand about these cases and so on, and you said something to me that I have been thinking about ever since you said it, because clearly we've got a lot of difficulty. We're in pressure in the village, the type of homes that are being built, not just in the flood plain, but all over the town and so on. And you said something that I thought was wonderful, and that is that you thought that we should look at the zoning regulations and height regulations that the village of East Hampton has adopted and maybe just go with that. And that and I would like the board to think about this and the advisability of it, because I think that, frankly, we're apples and apples. We're both the two biggest communities in the Hamptons. I think they've done a great job. Some of it's, how much foresight it needs to anticipate the real estate explosion that has overwhelmed the Hamptons. So I think there's to some degree, some luck involved. But in any event, clearly, we've become the most vulnerable of all the Hamptons. In your original letter to the Planning Commission, you cited West Hampton, Quogue, Town, height levels, and so on. And boy, I would think one of the things I fear now is that the Planning Commission is going to come in and they're going to have some new. It's going to be. I used to read a children's book to my kids, and this has got to be 70 years ago. Or almost. A story
Kids
called
aren't
The Church. No, you're right. Yeah, that's right. I didn't have children when I was 9. You're absolutely right. It was a long time ago. Anyhow, there was a book called The Turkey-Goose, and it was about this bird that was part chicken, part turkey, part duck, and part goose, and I sort of don't want to get in, take a little from Quogue, take a little from West Hampton. I would almost rather adopt what East Hampton has. And I think their FEMA regulations, you'd think that there's one set of regulations, we'd all be under them, yet they come up with a different calculation than we do. So I would like us to just think about adopting theirs, and maybe we could kill this bird in a couple of months, just start there, because you can always revise it. Once you've got it in, if you find out it's too difficult or even too generous, you can revise your building codes at any time you want. But it certainly, I foresee us getting into another free-for-all when they finally show up with their recommendations, and then people start picking each little aspect of it, and it gets beat up and you're black and blue by the time you're through, whereas if you'd adopted East Hamptons, and then if it's inadequate in some fashion, why change it? But anyhow, I loved your idea, and I really think we ought to consider doing it, and it would short-circuit all this. This has become, we live on the beach. I sometimes think it's become more like Omaha Beach than Southampton, and it's so disturbing. And some of the things that have happened, and not just on the beach. Throughout the village, there are things that just, damn it, are too overpowering. So anyhow, and you brought up this business that I didn't even realize, that the pyramid law only applies to half acre and under, and so on. And you suggested it should apply throughout the. I couldn't agree more. Anyhow, let's talk about it at some point, and maybe we could speed up this whole thing and avoid 10 more of these.
We have a professional planning study.
I know.
That's underway.
I know, Rick. I understand it. Yeah. But I wish. I'm just guessing at what it's going to be like when they present it.
Whatever we end up doing, you have to anticipate that somebody's going to bring a lawsuit.
Yeah.
If we're backed up by a detailed planning study showing that we looked at all the options and they made a judgment, and you're going to be far better off than rushing into something.
You're probably right, but I will say this: East Hampton's rules have been in existence for a long, long time, and you're adopting something that works. So anyhow,
I would say in the last 6 or 7 years is when they revised their height. And I think that one of the big differences between us and East Hampton is that they actually have less homes in the flood zone area that are impacted by the FEMA regulations.
Sure.
So because they don't have a great, got a huge estate area, but a lot of the estate area doesn't fall. Isn't impacted as much as what some of our areas are. So, but, you know, there's a lot of similarities, but there's some differences and stuff. So, but I mean, I love the way they put it together. They did it based on lot size. They did, a lot of great things that they did with that law. So, but I'd be curious to see what chicken these guys come back with, and to support what we're trying to accomplish here. But, they're doing a lot of work, and we've put some pretty good deadlines to try to get this done before the 6-month time frame. And that's but yeah, no, it's
just a suggestion, but
no, it's and I mean, I said it, and I completely agree with it, and I think that if we use those numbers, but I think we have to
process, right?
yeah, do the process. So okay.
Next case.
Yeah.
I won't make any comments at the end of the meeting.
No, that's
on
okay.
anything.
That's okay. All right, good.
Highway Department quit. Or maybe we should say half of them should.
Don't say that too loud.
Yeah, Charlie, you didn't pick that up, did you? I'm only kidding.
Okay, so let's do communications to the board here.
One from the Hispanic Apostle of the South Fork. On behalf of the Hispanic community, I would like to thank the Village of Southampton for the cooperation and assistance you have extended to us in the past years during our activities. Again, this year we're planning to celebrate the Feast of Our Lady of Guadalupe on Friday, December 12th. As in the past, we hope to have 2 outdoor activities on that day. One, run with the torch, approximately 3:30 to 4:30 p.m. This activity consists of runners carrying a torch followed by a bus and several other vehicles. We'll begin at Red Creek Park, north of Hampton Bays, and will end at Sacred Hearts of Jesus and Mary Church, 168 Hill Street in Southampton. I've already contacted the town of Southampton for the portion of the run outside the village boundaries. In the past, the town police have accompanied us from Red Creek to the Southampton village line. We request police accompany from the village line to Sacred Hearts Church. Number 2, procession from Agawam Park to Sacred Hearts of Jesus and Mary Church, 5 to 5:30 p.m. This activity is a walking procession of approximately 200 people from the park to the church at 168 Hill Street. The procession is done on the sidewalk, but we cross 2 streets. Again, we request police accompany for the procession. Thank you in advance for your help. Sincerely yours, Reverend Stephen Grazio.
And, we do this every year, so I'd like to make the motion to authorize the Hispanic Apostolate of the South Fork to do their run with the torch in accordance with their letter and application dated October 15th, 2014.
Second?
I'll second that one.
All in favor?
Aye.
Resolutions. Item 1, resolve the reading of the minutes for the work session on October 21st, 2014 be dispensed with, and those minutes be accepted as filed by the village administrator, and the actions taken at that meeting be and hereby are ratified and approved. Have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Item 2, resolve that the claims for the warrants dated November 13th, 2014, totaling $372,117.78. Warrant 8 General Fund, $95. Warrant 6 Trust Fund, and $133,401. Warrant 6 Capital Reserve Fund, and the village payrolls for the period from October 17th, 2014 to November 13th, 2014 be ordered and approved. Give a motion?
Make the motion.
Second? Discussion? Item 1, Aldo Angioli, November 2014 engineering fee, $3,250, page 2. Brant Steinberg, Scar Settlement, $1,180.03. Was due $1,802, garage supplies for October. Page 5, Cash Productions, October Video Services, $1,706.65. Page 6, Cleary Consulting on Beach Plum Meadows, application $1,350. Display Sales Company, Holiday Lights, $1,795. This amount was reimbursed by the Christmas Committee. Payments to Eberhard Nurseries for trees and yews, $1,620, $2,160, $2,475, and $2,835. Page 7, EMT Accounting Services for October, $1,392.70. Firematic Supply, hose elbows for the fire department, $1,609. Page 8, Firematic Supply Truck Repairs for the fire department, $1,174.76. Fundamental Business Services, court fines, October 2014, $2,572.50. Page 9, Greenblatt Ambulance uniforms, $3,975.61. H2M Architects and Engineers, initial deposit for the Sewer District Consulting, $10,000. Herrick Hardware, flowing on to page 10, October supplies in the amount of $1,222.84. Incident response technology, software and support for the fire department, $4,124. Page 12, Johnson Electrical, traffic signal maintenance, $1,350 for October. Page 13, Liberty Ironworks, modifying chairs and tables at the fire department, $1,598. Lynch's Garden Center at the bottom of the page, going on to page 14, October supplies, $2,549.28. Mulvi's equipment, mower parts, $1,428.74. Messiano Consulting Services for October, $2,075. More medical supplies and medicines for the ambulance, $2,486.93. Morgan Auto Supplies for October, $1,772.44 for the garage. Murphy and Lynch, two tax settlements, one for 154 Gin Lane, $44,021, and 140 Gin Lane, $74,795.38. Page 16, Norsec and Sons October Carding, $4,185. Office of the State Controller, August fines of $22,558 and $10,760 for September, for a total payment of $33,318.50. Page 17, Power Equipment Plus chainsaws for the Highway Department, $1,328.72. PSE&G lighting for the Building Department, $2,554.05. For PD, $3,973.92. Street lights is $6,271.61. And on page 18 for the Fire Department, $3,878.95. Out on the page, going on to page 19, we have electrical supplies for the building and street lighting in the amount of $1,186.23 and $889.89. Robinson & Robinson, Planning Board and ARB services from June to November, $14,165.48. Page 20, safety marking for North Sea Road, striping, $19,311.20. Page 21, Stryker EMS mattresses for the stretchers, $4,000. Suffolk Cement Products, Highway Grid, $1,140. Syntax Communications, this is the PR work for the ambulance bond, vote, $6,095. Page 22, State Insurance Fund, insurance payment, $1,487.77. Vince Toomey, October legal fees, $19,236.89. Payment to the trust account, this was to reimburse for overpayments on taxes that was treated as a tax sale redemption erroneously, is $14,706.84. Page 23, temporary security for Job's Lane, $1,455.42. United Metro Energy, 2,500 gallons of gas, $5,917.75. And Verizon Wireless, $1,701.74. Capital Reserve warrant. First item is Firematic Supply, first equipment for the fire department, $48,285. JP Mulvey, payment for the heating system at Village Hall, $60,000. Motorola Solutions, fire department pages, $2,505, and two payments to Trias for the highway spreaders and a park spreader, $8,281 and $14,330. Further discussion? All in favor? Aye. Resolved that the Board of Trustees hereby approves the hiring of Nicholas Berlin as the grasshopper for the Parks Department at an hourly salary of $11. Have a motion?
Make the motion.
Second? Second. All in favor?
Aye.
Can I ask you something?
Sure.
Isn't grasshopper usually a seasonal?
Yeah, but a lot of them went back to school, and until he gets the leaves cleaned up, he likes to extend them into further into December. And this guy's out on a break, so taking him for a couple weeks.
It's temporary, oh,
Yep.
yeah, good.
Item 4, resolve that the Board of Trustees hereby approves the attached schedule of budget transfers to eliminate overages through November 13th, 2014. Have a motion?
Make the motion.
Second?
Second.
Discussion. Item 1, $4,000 to Justice part-time from Justice contractual. Item 2, $11,000 to DPW equipment, $1,000 into elections, with $12,000 coming from contingency. And the last one is $1,000 into highway clothing, coming from street maintenance supplies. All in favor?
Aye.
Aye.
5, resolved that the Board of Trustees hereby approves the following payments from the Capital Reserve Fund, subject to permissive referendum. JP Mulvey Plumbing, $60,000 from Facilities Reserve. Motorola Solutions, $2,505 from Fire Equipment Reserve. Trias Incorporated, $22,611 from Major Equipment Reserve, and $48,285 to Firematic Supply from the Fire Equipment Reserve. Motion?
Make that motion.
Second?
Second.
All in favor?
Aye.
Aye.
Okay, discussion items. Just want to, the results for the ambulance bond vote was 217 to 100 in favor, which was held on October 31st this year. All right. 217 to 100. And item 2, a while back, there was a presentation to remove a section of the wall on Job's Lane. They applied for a grant. The grant was approved. And I know it was still a discussion whether they wanted to open up that section of the gate. We can modify the plan, but it was approved.
Can we modify it and not open the wall?
Yeah, absolutely.
Okay.
Absolutely. So
anything that applies to improving that area.
Right.
That everybody
The-
agree on
you know,
can
the
be
plan
useful.
is in here, the sketch is in here, but take a look at it. That's what the whole walkway behind
Right.
that gate. The one question that was open with the board is whether that 8-foot section of that fence would come down to make it accessible in there. So before Jen goes forward with this, it has to be back by early December, date in December.
Well, because, Rich and I were talking about this the other day, and what we should do is, and it was brought up before, is go back to CMAC and look at possibly, there's that 13-foot section on the western side of the wall.
Uh-huh.
We have that one opening right there, maybe expanding that opening right there.
That I wouldn't care
which-
about.
And you can make, we were discussing, you can mimic it to look like the rounded entrances to the main part, or whatever.
Yeah, kind of, round it out to kind of, like you were
That's
just
what's
saying.
for the main building?
The main
to
building
kinda
and
look
stuff.
like that.
Maybe trying to do something like that.
Mm-hmm.
Existing opening.
'Cause I know that, CMAC had worked on this one entrance here.
Right.
Dedicated some time and money to do this, but maybe it's an opportunity for us to, I know what we're trying to do is open the property up and allow greater access.
Yep.
You take that one section of the wall out, maybe that would do that.
Right.
So,
Yeah, it's not really used down that end.
yeah,
Mhm.
it's really, that gate always, I walk by that all the time and I find that gate is shut all the time.
Yeah.
Down
I mean,
here
they did
it's shut?
best they
Yeah,
could
on
to
the,
make it
on the
more
western
inviting.
side,
but-
it's
Really?
shut all the time, and I
Really?
open it up,
Swing
and I come back, walk by 2 days later, and the thing's shut again.
Interesting. Okay.
Yeah, so it's,
We need one of our cameras.
here we do.
Just remove the
Find who's.
Well, I think we should take a police officer and station them there
There you go.
full-time and 24 hours a
Open the
day to
gate.
prevent that
There
from
we-
happening.
There we go.
So,
Invite people
yeah.
Leave the ignition running and keep the radios going?
That's right.
Okay. Suggested. All right, and the last item is, Rick, the Meltzer declaration here.
Okay, if you remember, this came up at the September meeting of the Board of Trustees, when Gil Flanagan presented the request. Don't want to go through the whole thing again, but just to briefly summarize it, back in 1990, got to back up to 1988. In 1988, the Board of Trustees adopted what's been called a wetlands moratorium resolution that required that applications be made to the Board of Trustees for relief from that resolution for projects in relation to wetlands. That was when the village was first starting to study developing its own wetlands code. And this was one of those applications. The Board of Trustees granted the requested relief and imposed a condition that there was a flagpole strip of land that's near freshwater wetlands, and the board imposed a condition that basically said no alteration to the wetland, that strip of land without coming back to the Board of Trustees. Subsequent to that, the village's this is freshwater wetlands. Subsequent to that, the village's freshwater wetlands regulations were accepted by the state and became effective as to freshwater wetlands. And now, as you know, all wetlands applications go to the Zoning Board of Appeals for a wetland special permit under our code. This is one of those old things that's hanging around out there. There's no reason to have them have to apply to you and then to the zoning board when it involves the same wetlands. So what we talked about was terminating the old declaration that required them to come to you, because that's no longer needed, because now there's a law that says they have to go to the zoning board. Back at the time that the condition was imposed, we didn't have a law that was applicable to freshwater wetlands. So since then, per our discussion, Gil Flanagan prepared a draft legal document. I looked at it. I told him I wanted some revisions, and he's agreed to the revisions. So now it's ready to go, except we need the formal resolution from the Board of Trustees to authorize termination of the old declaration. And I prepared a written resolution, which you have in front of you. If that's adopted, Joe would then have his client sign the legal document and then give it to me to be signed by the mayor.
Okay.
If you're okay with it, you can just make a motion to adopt the written resolution and annex it to the minutes of the meeting.
Any comments from the board on this? I think it's
No,
pretty
it's pretty clear.
straightforward and stuff.
Gil covered it last time.
I'd like to make a motion to approve the resolution, reason the Meltzer declaration in accordance with the document in front of us.
Second?
Second?
All in favor?
Okay. Pretty long meeting. I haven't had one of these in a while, so we're gonna, comments from board members here. Trustee Yaz?
Just a couple of things. First, on a local micro level, I want to thank everyone who showed up to vote, as we just announced the results, who showed up to vote for the ambulance bond vote to approve that. Much appreciated on their behalf. I want to thank everybody who showed up to approve that for a much-needed facility. It's a good chunk of money. Everybody knows that. Mostly us, we do know. It's not a small sum of money to ask to approve, but, and there's comments, yes, would like to see maybe a smaller number, but, we did the best we could, and this is a number that was required to build a facility that can hold up for what's required for today and what can hold up for what's needed in the future. So, I thank everybody who worked on that to get it to this point, and I thank the public for approving that. On a macro level, on a larger level, I want to thank Tim Bishop for his service to this community as our representative for the past 12 years. Irrespective of what party you sit on or represent or like or vote for, one thing that was important about him, in my opinion, was that he was in our backyard. It was, to me, comfortable knowing that every level of our government, from to where we are to federal and everything in between, basically sat in our backyard between here and the East End. So that was a nice comfort level to have as a legislator, a local legislator, and it was nice to have that backup on a federal level, and have him as a resident here, literally living around the corner from us. So he did represent the East End well, and a lot of our particular concerns that we did face out here on an environmental level and others. So I thank him for his service to this area, and I do congratulate Mr. Zeldin and wish him the best of luck, and I hope he reaches out and works with the mayor as much as Mr. Bishop has in the past.
Great, thanks, Rich. Mike?
I would like to make a comment in regards really to the building department. The building department, if anyone spends any amount of time down there and watch the goings on, they certainly have their hands full. And Mr. Forster in particular does a terrific job under the circumstances that he's put up against. It is a difficult village. The numbers are huge on most of the real estate. There's an incredible amount of tear downs in the smaller smaller lots, and it is a very difficult position to be in. I support them all. They do a great job. Hopefully that going forward, we can come up with some terms and changes that will make their job easier and make their position a lot more part of the community.
Thanks, Mike. Vance?
A couple of things. I think I mentioned once before that this 2015 is the 375th anniversary of Southampton, and there is a committee that I sit on for activities throughout the year starting in January. One of the things which I believe Susan College gave the village, and I haven't seen it yet, so I don't know if it's lost, but she asked me about it. There was a meeting today. They want to create sort of a small hut.
Mm-hmm. Yeah, you and I spoke about that.
Yeah, that is at Dunwell Park, because that's approximately where the first settlement was. And she included pictures of what it would look like. I think the board members need to see this. Mm-hmm. I thought it was basically, not harmful in any way whatsoever. In fact, I think it's a great idea. And it will be there is going to be a walk that goes from Conscience Point all the way through and takes the walk to where it is down there to Dunwell Park, and they want these little huts set up. And part of it is that they're trying to harvest now natural materials that they would have used, such as the Phragmite and other things. And now is the time that they have to harvest it so that they can keep it, so that they can put this hut together next summer, I guess in June. So I think we need to say to them that they can do this. We would like them to do it. I know there's an she said she dropped off something to you. Do you know where that is? I have it. You do have it. So we need to look at that so that we can say, please move forward with it, because she's been talking to lots of people. They're starting to harvest, but she said, can we do it or can't we do it? I told her I didn't ask, but I'm asking this evening. So we... Okay, but doesn't say anything about the huts? They're basically, they look like pup tents practically. I mean, that's what it is. It's not any big building or anything. And it was just a shelter, more or less, for those people who were here. So anyway, I think we need to look at that, and then I think we need to give them permission on that. And the other thing is, Mark, do you want to talk about our meeting that we were at yesterday?
Yeah, you go ahead.
Okay. Mark and I attended a town meeting yesterday. Basically, they've undertaken a study on County Road 39. They presented the study to the Suffolk County Planning Commission. Attended those two meetings where Kyle Collins spoke about their plans for the improvement of County Road 39 as it relates to businesses along the roadway and as it relates to improving it with businesses so that there's not as many curb cuts. Part of what he had explained in this study was that they broke it into 4 quadrants. So the quadrant 1 is your entrance off of 27 onto County Road 39, and how they would like to do a planting plan for that, which is lovely, and all of that. And then we moved along the highway, and then we got into quadrant 2. Quadrant 2 includes the driving range and the Elks. It also shows how much of the preserved property is with all the golf clubs. They indicated in the study that they wanted to purchase the development rights for the driving range and for the Elks because they felt that should not be developed. And then they are asking at the same time between McGee Street and the cutoff for Sandy Hollow, the exit of Sandy Hollow Road, on the south side, they want to change the zone from highway business to shopping center. So the question was, have you made arrangements to purchase those properties, the driving range and and the Elks Club, because I haven't seen anything, and I haven't heard anything that they're purchasing them or they're using community preservation, which the mayor says they cannot use community preservation because both of those properties want to continue to run them as businesses, and you cannot take community preservation and allow them to run a business there. It has to be preserved property. So I asked that question yesterday, have you made arrangements to do that? Because the taxpayer has a right to know how you plan on doing that. I didn't get an answer on that. But then one of the owners of the driving range appeared on the scene and wanted to understand what's happening there because he hasn't heard from them. So they really basically have not done anything on that, but they have included that in the study as what they intend to do. Well, what you intend to do and what you're doing are two different things. So my point was, if you do not nail that down and you change a zone to shopping center, who's to say that shoots the value of those properties through the roof? So they didn't answer that. They didn't answer that. So the bottom line is this: they intend to take an area that is highway business. The reason why it is highway business is because it's a low trip factor. You don't buy a car every day, you don't buy a couch every day, you don't buy carpeting every day. Those are the businesses that have been allowed to be on County Road 39, and now they want to change it to shopping center. And that sits between McGee Street and the cutoff of Sandy Hollow Road. And they will have an entrance and exit on McGee Street. If they have an entrance and exit on McGee Street, quite honestly, that's going to be the favored route to go, because crossing County Road 39 to get into that shopping center will be absolutely impossible. And besides, they shouldn't have a shopping center on County Road 39. That's one of the reasons why they zoned it the way they zoned it. So we went and we spoke with them and we told them that the village is not in favor of this. They do have to go through more of a procedure at this point, but we're watching this very carefully. We hope that the people who live on all of those little side streets come out and say, do you want an increase in traffic? That's what you're going to get. You're going to get an increase of traffic going down your little streets if the town proceeds to put a shopping center between McGee and Sandy Hollow. So, do you want to add to that?
Actually, can I just ask one thing?
Mm-hmm.
Because the meeting that you referred to, the last one, I couldn't stay as long as you did. But when I did leave, they were bringing up, one of the board members on the planning commission, were bringing up the point, we're questioning how much involvement had they received from neighboring municipalities. Right. How did they enter? Because I got the impression they were saying that we were all aware of it.
Well, they said that, yes, of course they were involved, which we were not. And we brought that up, and then they tried to argue that point. But they said, oh, yes, they've been involved. And Barbara Roberts is the member of the Planning Commission, Suffolk County Planning Commission, who brought it up. She lives in North Haven. North Haven and East Hampton, a member from East Hampton was there as well. And they are concerned because just to give you an idea, 18,000 people cross the doorway of Walbaum's on a weekly basis. That is a much smaller supermarket. What they want to put over there is a 40,000 square foot supermarket. So can you imagine the amount of traffic that's going to be going in and out of that supermarket all year long, up and down our little side streets? West Prospect Street is going to become a thoroughfare. So, she has great concern, and she indicated that she is going to get to the bottom of this. And she is going to make sure that everybody is aware of it. I think that's a great thing, because they should be aware of it. But it is alarming. It's alarming to think that they're not getting it, that they're moving forward with this and they're not getting it. And they're not getting the effect that it's going to have on this community. And quite honestly, I don't think they care. So, and we care.
They don't care.
I know.
They don't care.
Well, they lump it in with all their other PDDs they got going on, and some which actually may have some benefit. This isn't one of them, but I got that impression. That's how they were presenting it to the commission. This is just one of several PDDs they got going on for the benefit of everyone.
And they also talked about the Tuckahoe, what is it,
CAC.
Oh, Kyle said, oh yes, the Tuckahoe CAC is in favor of it.
Yeah.
Wrong. not in favor, because there were members there who said, we've never been in favor of this. So he presented that to the Suffolk County Planning Commission, said they were in favor of it, because he talked to one person who was a member there and seemed to be in favor of it.
Yeah, it was an interesting meeting, so.
Step one.
Well, the County Road
The
30.
planning commission thing was very educational. To go to see how that unfolds is, to me, I found very educational to see how that level of that system works.
So the County Road 39 corridor plan is 1/3 of that is a village boundary. And then, so the supervisor's belief on the village's input is that we received a letter after the plan was complete, and that we've had an opportunity to go and make comment about the plan. Unlike the other 9 people that they had invited to participate in the development of the plan and sit down with Mr. Fish from BFJ Consulting to help develop the plan. So here, one of the major stakeholders, the village, and even the 1970 master plan states that the village is a major stakeholder in this area. They didn't invite us or anyone, even a resident from the village, to even participate on the plan. So it was a pretty disappointing piece. So, so I think we let them know that too. So
I think we let them know that, but we can't let our guard
Yeah.
down. We have to stay on top of it.
Yeah.
Continuously.
Yeah. So good, Bill.
Well, I promise not to say anything, but
That's okay.
Rich, you've inspired me with your little speech about Tim Bishop. 2 years ago, after Hurricane Sandy, I'll just tell you something that I said to him. I said, 2 years before that, Tim had won an election by 300 votes, and I think it took three weeks to count the absentee ballots. And so, you know, they were out to get him and killing themselves to do it. I said, Tim, you want to do something that's going to really, the name Tim Bishop will mean something throughout this whole country. I think what you should do is introduce a bill in Congress that for roughly a 4-year period prohibits all immigration to this country from the Islamic world until they've gotten all their boilings out of their system, and if you want to let students come in, do that. But I said, you know what, we're going to have some trouble with those birds, and ISIS hadn't even shown up at that point. And I told one of his assistants, I said, and I really meant it, honestly, I think the Islamic world, we're going to see a plane shot down with a Stinger missile or a shoulder-fired missile or a biological weapon or this new crowd. Their revenge is a virtue with them, and they're going to get even with us if it's the last thing they do. And they think they make themselves taller by making somebody else shorter. And I wish he'd done it. And I think Tim would have been a landslide. A whole lot of people would have agreed with me. Anyhow, so that's my village politics for today.
Yeah, it's a little bit.
Village. That's a little outside the village boundary.
Village pay scale there on that one.
I just wanted the second one Rich had said about the ambulance barn. I want to thank everybody for coming out and supporting those guys. And it's a great group of people that really do a tremendous service to this village. And Veterans Day, we had a nice turnout on Veterans Day. It was a beautiful day. And, you know, congratulate Kenny Lockhart Jr., which we gave a proclamation to, and Colonel Nolan, who was from at the air base, came over and gave a great speech. And so it, but encourage more veterans to step up, get involved. We have, you know, Veterans Day. We do 4th of July, Memorial Day, and it's really. Those are events that show up in March, and then get involved with some of the veterans groups, because a lot of these guys are, you know, moving on, and it's we have a lot of veterans that are out here that don't get involved, and encourage them to do that. And it's, like I said to Kenny Lockhart, he really is not going to appreciate his time in the military until he's been out for 10 or 15 years, and he looks back and realizes what a great opportunity it was, and what a great service to his country it was. So encourage people to do that. And although we do have a meeting on Tuesday the 25th, Saturday the 29th of November is that's the Christmas tree lighting and the parade of lights, which will start at 5 o'clock on that Saturday, or as soon as it gets close to dark. And it's always a great event, and And then, when this holiday season rolls around here, I want to just encourage everybody to shop local. And part of our battle with County Road 39 and the potential of basically the way that corridor study laid out, they laid out a perfect supporting document for Home Depot.
Mm-hmm. They did.
With the terminology about garden centers and building equipment and on and on and on. They described Home Depot to the T.
They did.
And they said this is exactly where it belongs. And so, but that goes back to, the way to keep big box retail out of here is
Basically,
to support local merchants, people that live and work in this community, that run retail outlets and restaurants and the delis and stuff, and support the local organizations, because they volunteer in the fire department and the ambulance department. They support all local charities. They do all of these things that makes this community a great place. And so we got to shop local and support our local merchants and restaurants. So.
And that isn't a Home Depot.
And that isn't a Home Depot, because they take their profits, and it's on Wall Street, and they come out here and buy homes. So. Yeah, so.
They buy homes that then come before the board that they're all fighting over.
That's right.
Yeah, exactly, right.
So with that being said, I have a second public comment section. Anybody from the public would like to come and speak? Okay, I'll make a motion to close the public portion of this, adjourn to executive session for the purpose of discussing employee matters.
Second?
Second.
In favor?
Aye.